Yes, record an order. Learned advocate for the appellant is present. None appears for respondent number 2 and 3 in spite of service of notice. With regard to respondent number 1, as the said respondent has left the address, which was the address mentioned in the cause title of the original claim case, service of notice upon the said respondent is dispensed with for the time being only with regard to the application under Section 5 of the Limitation Act. Stop. The application for Section 5, the application under Section 5 of the Limitation Act, being Can 2 of 2026, is taken up for consideration. Hard learned advocate peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned, and the appeal is admitted. Can 2 of 2026 stands disposed. Stop. The application Can 1 of 2026 is taken up for consideration. As the appellant insurance company has deposited rupees 20, the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 12th day of December 2025, passed by learned additional district judge, first track, second court, Barashat, North 24 Parganas, in MSC case number 159, 2018, for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount, before the Registrar General, High Court, Calcutta, within 5 weeks. Stop. In the event the entire compensation is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. এবার রেজিস্টারের ওটা আছে, ওটা করে দেবেন।
One humble prayer, my lord. I have the entire set of exhibited documents with me and the depositions. My lord will call for the TCR in its usual course, my lord, because it's North 24 Parganas, Barashat.
The notice be issued upon the respondents, the appellant shall issue notice upon the respondents personally through registered post as well as through the department by filling up necessary requisites and forms. Stop. The trial court records be called for and the paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
I'm extremely grateful, my lord.
Note 62 is insurance appeal. It's appealing for the first time. Lord, I was paying for interim stay. I made the statutory deposit, my lord, and I also
This is Can 1 and Can 2.
Can 1 and Can 2, my lord. Can 1, my lord, is the condonation of delay application.
Okay. It is disposed or not?
No, my lord. It's appearing for the first time before your lordship, my lord. May I just hand over the appeal service, my lord? And the statutory
Service is
deposit
complete.
service is complete, my lord.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Stop. The affidavit of service file be kept with the record. The application Can 2 of 2026 is taken up for consideration. Hard learned advocate peruse the petition file. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the appellant has shown sufficient ground for condoning the delay of 4 days. Thus, delay in preferring this appeal is condoned. The appeal is admitted. Can 1 of 2026 stands disposed. Stop. The application for stay being Can 2 of 2026 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 28th day of November 2025, passed by learned additional district judge, Second Court Asansol, in MSC case number 16 of 2015 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation amount along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. We register ওটা করে দেবেন। The appellant shall cause service of notice upon the respondents personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records will be called for at the special messenger post.
I've got this entire certified copy. Let it come in usual course, certified
The
copy.
trial court records be called for and the paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
My lord, your lordship has directed my lord's officer to invest it in my lord renewable fixed deposit. Extremely grateful, your lordship.
It is always that
That part is always,
excluding 25,000 is always implied.
and my lord for investment part.
So that is there. Even if it is not mentioned in the order, it is implied.
Lordship.
That excluding 25,000.
Obliged to my lord.
Lordship, I'm for the appellant, your lordship. I'm filing the affidavit of service and sum of rupees 25,000 has been deposited.
This application for stay.
Yes, your lordship.
Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 17 January 2026, passed by learned additional district judge, First Court Chinsura, Hooghly, in MSC case number 12 of 2020 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum, including interest as directed by the learned trial court, excluding the statutory amount, within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The register করে দেবেন। The appellant shall cause service of notice upon the respondents personally through registered post as well as through the department by filling up necessary requisites and forms. Stop. The trial court records be called for and the informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Lord 64, my lord, is the insurance appeal. It is appearing for the first time. My lord, may I give the statutory deposit receipt, my lord, and my lord, the affidavit of service. My lord, this affidavit of service I must indicate, my lord, as far as the owner is concerned, it has come back, my lord, that with the remark that the name of the village does not exist. My lord, I have in my affidavit, I have stated, my lord, whatever is given in the cause title, I mean of the claim application. Lordship will kindly have a, my lord, I'll have a look, my lord. It's Lordship will kindly see, my lord, the address, village Molbagan, MOLBAGAN, in the claim application.
Opposite party number 2.
My lord, opposite party number 2, it has come back with the remark refused. So, my lord, that is a good service.
Opposite
But my lord,
party
with
number 2 is refused.
Lordship, my lord. So, that is a good service with regard to number 1. Your lordship will kindly have a look at the claim application. Molbagan. My lord, I have given the copy of the claim application to your lordship. My lord, will kindly see. The first address starts with, my lord, Molbagan. And the postal department says Molbagan, they do not know. So, my lord, I have got no other option, my lord. So, that your lordship will kindly, my lord, allow my condonation.
Learned advocates for the appellant is present. The service of notice caused upon the respondent number 2 has returned with the remark refused. Stop. As refusal is a good service, the notice is treated to be duly served upon respondent number 2. Stop. With regard to the respondent number 1, as the appellant has caused service of notice at the address which was mentioned in the cause title of the claim application, but the same could not be served by the postal authority as the said on the ground that the said village does not exist. The service of notice of section 5 application upon respondent number 1 is dispensed with at this stage. Stop. The application for condonation of delay is taken up for consideration. Heard learned advocates for the appellants peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Can 1 of 2026 stands disposed. Yes, where is Can 2?
Okay, can you just stay application, my lord, is there with your
The application Can 2 of 2026 is taken up for consideration as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be ad interim order of stay of the judgment and award dated 24th day of September 2025, passed by learned additional district judge, First Track Court, Bankura, in MSC case number 86 of 2017 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. And the said deposit shall exclude the statutory amount. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents personally through registered post as well as through the department by filling up necessary forms and requisites. The trial court records be called for
forward certificate.
and the informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Extremely grateful, my lord. I am obliged, your lord. My lord, may I take back this
Yes,
claim application, my lord?
take back.
Copy of claim application. এই রিসিপ্টটা নিয়ে নিন 25,000 টাকা রিসিপ্টটা নিয়ে নিন appear for the appellant insurance company, my lord. Appearing for the first time, there is no delay.
Yes. The learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 9/3/2026, passed by learned additional district judge, First Track Court, Durgapur, Paschim Bardhaman, in MSC case number 223 of 2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount, within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The trial court records be called for. Acha. The appellant shall cause service of notice upon the respondents, both personally through registered post as well as through department by filling up necessary requisites and forms. The trial court records be called for and the informal paper book be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Six. I'm for that. That's it. Now, there are two applications. One for the section 5 delay application, and another for stay mallet. This is my everyday service mallet. That will be enough.
Service is affected.
Mallet, regarding respondent number 1, question mallet, endorsement says door locked. Regarding respondent number 2 and 3 delivered.
What is the claimant?
One is the claimant, respondent number 2 is the claimant, mallet 2 and 1 is residing at the same address.
Yes, record and order, learned advocate for the appellant is present. None appears for respondent number 2 and 3 in spite of service of notice. However, with regard to respondent number 1, it could not be served as the door was locked. Stop. The service of notice of section 5 application upon respondent number 1 is dispensed with at this stage. Stop. Hard learned advocate for the appellant peruse the application under section 5 of the Limitation Act. Upon perusing the application and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application Can 1 of 2026 stands disposed. The application Can 2 of 2026 is taken up for consideration. Hard learned advocate for the appellant. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 26 September 2025, passed by learned Additional District Judge, Fast Track Second Court, Bardhaman, Paschim Bardhaman, in MSC case number 59 of 2015 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop.
Less statutory.
It is implied.
Otherwise,
Such deposit shall exclude the statutory amount. In the event the entire compensation is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents personally through registered post as well as through the department by filling up necessary requisites and forms. Informal paper books, the paper books be prepared, the trial court records be called for, and the informal paper book be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Lord 67, Lord, is the insurance appeal. Lord, this is also appearing for the first time before your Lordship, Lord. Lord, I have made the statutory deposit. Lord, I have served upon all the respondents.
I am for the respondent number 2, National Insurance Company. Respondent number 6.
Now, this is the statutory deposit. Section 5.
Lord, section 5 is there. Lord, the condonation of delay. Lord, Can 1 is there.
So service is affected upon all.
This, Lord, is like again, Lord, like the last matter. Lord, I have served it, Lord, at the address given. It has come back, Lord, that it is not the proper address. Lord, the claim application is again the same thing. Lord, do not know, Lord.
This is Can 1.
Can 1, Lord.
So for Can 1 is concerned regarding.
Lord, I'm sorry, Lord. Condonation is Can 2. Condonation is Can 2.
Now, so for Can 2 is concerned
Not sure.
regarding respondent number 1.
Lord, 1 and 2.
It has returned.
1, 2, and 3. It has come back, note with the remark that no such person in the address. Your Lordship will kindly have a look at my affidavit service. No such person in the address.
And
the
4, 5?
address, Lord, 4 and 5, Lord, it has come back. 4 has come back with the remark that the letter returned incorrect address. And 5, Lord, that addressee has left.
And you.
With 6, my Lord,
Yes, Your Honor,
is appearing.
When is appearing.
So, my Lord, I have served all, but my Lord, at the address given in the claim application, 1, 2, 3, my Lord, says that that address is wrong. 4, my Lord, and 5 has come back with remark they have left. And 4 is also, my Lord, with regard to incorrect address. But I'll serve them again. My Lord, let this delay be condoned. Stay be
Yes,
granted.
record and order learned advocate for the appellant and learned advocate for respondent number 6 are present. The service upon respondent number 1, 2, and 3 could not be affected as the registered envelope has returned with the remark that they do not reside at the said address, although in the cause title of the claim petition, such address was mentioned. Stop. Similarly, with regard to respondent number 4 also, the service could not be effected on the ground that the said person does not reside at the address.
Lordship.
With regard to respondent number 5, the service could not be effected, refused.
My lord, addressee left.
Okay, on the ground that the addressee left the address.
Lordship. With regard to 6, it is
Respondent
completed.
number 5, the service could not be effected as the addressee left. Thus, for the purpose of section 5 application, service upon respondent number 1, 2, 3, 4, and 5 is dispensed with. The application under section 5 of the Limitation Act is taken up for consideration. Heard learned advocates peruse the petition file. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. The application for stay being Can 1 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an addendum order of stay of the judgment and award dated 25/8/2025, passed by learned additional district judge, First Court HON'BLE at Chinsura in MSC case number 137 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation amount along with interest, excluding the statutory amount, before the Registrar General High Court, Calcutta within 5 weeks. In the event the entire compensation amount is deposited within 5 weeks, the addendum order of stay shall continue till disposal of this application. Registered order, ঠিক আছে? As the respondent number 6 has appeared, service of notice upon respondent number 6 is dispensed with. Stop. Service of notice because upon respondent number 1, 2, 3, 4, and 5 personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records we call for.
My lord, I've got the certified copies, my lord, in this case.
Yes, the trial court records we call for,
Obliged.
and the informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Extremely grateful.
Can 1 dispose? Now, can 2 ta condonation of delay, can 1 ta stay.
Your Lordship, I am appearing for the appellant in this matter. Statutory deposit. Statutory deposit. There is a delay, Your Lordship. This is the affidavit of service.
Service is affected upon all.
No, Your Lordship, we have served. There's an insufficient address. There's a loss of insufficient address, Your Lordship, in respect to 1 to 4.
All 1, 2, 3, and 4.
1 to 3 and 4.
It is written on the remark
Insufficient address. But this is the same address which has been mentioned in the claim petition.
Yes, record an order. Learned advocate for the appellant is present. As the service of notice upon respondent number 1, 2, and 3, 1, 2, 3, and 4 could not be effected, as the registered envelope has returned with the remark insufficient address. Although the address mentioned in the claim application was claim application was stated. Stop. Was stated. Thus, service of notice with regard to section 5 application is dispensed with. Stop. The application under section 5 of the Limitation Act is taken up for consideration. Hard learned advocates peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. the appellant shall cause service of notice upon the respondents personally to registered post as well as to the department by filling up necessary requisites and forms. The trial court record be called for and the informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
Deposit within how many week deposit?
Yes,
The entire deposit can two, the entire deposit within how many weeks?
5 weeks.
Deeply.
ওটা
Can
দিয়েছিল।
one.
The
Can one টা
applicant
section
insurance
5.
company shall deposit the
আর can
entire
two টা stay.
amount within 5 weeks. কোন জায়গায়? এটা পড়ুন তো কোনো অর্ডারটা একবার।
Appearing on behalf of the appellant, my lord. This is a very short point, my lord.
Can one is
Can one is the, my lord, leave to file appeal, my lord. Can one is the leave to file appeal and can two is the, my lord, the section 5, my lord. The point is that, my lord, in this order, my lord, on the date of passing of the judgment,
no service is not effected. Section 5 has to be effected.
my lord, evidence service is there, my lord. There, my actually, my lord, the opposite party is, my lord, Reliance General Insurance Company Limited, my lord. But now
How many days delay?
delay is, my lord, 405 days, my lord. Can two.
This is the claim case.
Claim case, my lord.
So claim case, why are you seeking leave? You are a party in the claim
No.
case.
Actually, my lord, the actual claimant is the Malay Kumar De. He was expired, my lord. So his legal heirs, my lord, Sikha De wife and the Tisha De daughter filing this appeal, my lord. My lord.
That
As
means
it- as because they
after the award was passed,
award was not passed, my lord. Matter was dismissed on the ground of deficit court fees, my lord.
so not on merits.
Not on merit. My lord, hearing has already been concluded. All the evidence has been completed on the date of the passing of the judgment that was dismissed on the ground of non-payment of court fees, deficit court fees. There was an application for a exemption petition has already been filed, my lord.
So section 5 and this leave application is served.
All are served, my lord.
Yes, you are appearing for the Reliance General.
Miss Gopadas Mukherjee, Mrs. Gopadas Mukherjee, she appeared.
So as because none appeared, no, now it is in the scene probably.
Now it is in the I have also served to the industry also.
So sub copy upon Mrs. Mukherjee. Okay, let it be taken up on Monday.
Gopa.
Okay.
Yes.
Appear for that. My lord, he also appears. Let him take instruction.
Okay, okay. Then you accept the service.
Okay, দিয়ে দাও
আপনি
অর্ডারটা করিয়ে দাও।
এটা লিখে দিন, আমি আপনাকে
Sub copy. Okay. Learned advocate for the appellant is present. As none appeared for the respondent insurance company,
ফোন নাম্বার
Mr. Shomallo Ganguly is requested to appear in this matter and take necessary instructions. Let this matter appear on 18/8/2026.
কবে দিচ্ছি?
For disposal, your lordship.
No, no. You take instruction. This application will be considered.
This is a very short point, my lord. Deficit court fees, my lord, similar.
Anyway, let your learned friend take instruction. Let us see.
Lordship had passed various orders. 70, my lord. My lord. I am also appearing on behalf of the appellant, my lord.
And for the respondent number 1, and there are 2 insurance companies. Well, here, it's the same, Malad, on the ground of non-payment.
Non-payment.
So two insurance companies.
Two insurance companies I have served.
What is you are representing which insurance company?
Both.
Oh, you are representing both.
New India and Oriental.
So
The person filed, Malad, that, Malad, order number 78. 31st July 2025. Deficit court fees, Malad, the claim is similar type of the Malad, demanded back the
In earlier occasion, my lord. Already passed order. Or the copy দিয়ে দিন। Copy দিয়ে দিয়েছি, এক copy হবে। ও ঠিক আছে।
let it be disposed. Yes, learned advocates for the appellant and learned advocate for the respondent, New India Assurance Company Limited and Oriental Insurance Company Limited are present. Service of notice upon respondent number 4 vehicle owner is dispensed with. The ground of challenge in this appeal is that the learned trial judge has dismissed the said appeal for non-payment of the deficit court fees. Stop. Upon perusal of the stop. As the motor vehicle claim legislation is the beneficial legislation and the appellant's claimants have already obtained leave under Rule 331(2) of the West Bengal Motor Vehicle Rules, the claimants appellants cannot be compelled to pay deficit court fees at this stage. Stop. As in the claim cases where there are deficit court fees and the compensation is awarded by the tribunals, the compensation amounts are not disbursed unless the deficit court fees are paid. In the such facts and circumstances, this court is of the view that the claimant appellant cannot be compelled to pay deficit court fees at this stage. The claimant appellant will be permitted to pursue the litigation till the date of passing of the award. The judgment and order dated
31st July 2025.
31/7/2025 passed in MSCC number 299 of 2009 is set aside. The matter is remitted back to the learned trial court, being Judge Bench 9, City Civil Court, Calcutta, to consider the claim case of the appellant in accordance with law.
One thing kindly observe that unless the deficit court is being paid, the award cannot be implemented.
Award cannot be implemented.
It
That
is, however,
that is
made
the law.
clear that unless the deficit court fees is paid, the award cannot be implemented.
And all application has been disposed.
Disposed. Application for
Condonation of
must only condone that.
আচ্ছা সবার উপরে লিখে দেবেন, হ্যাঁ, the application for condonation of delay, how many days delay?
293 days.
Condonation of delay is taken up for consideration, and in the interest of justice, the same is condoned.
Kindly give notice upon all parties.
The claim case shall be proceeded upon notice to all parties.
I must kindly fix up a date, my lord. This is a 2009 matter. Within a stipulated time can be.
As the case is of 2009,
Nine.
learned tribunal is requested to dispose of the case expeditiously and preferably within a period of 4 months from the date of communication of this order.
All applications.
All applications disposed of.
71, my lord, I am appearing on behalf of the appellant, my lord. Affidavit service is there, my lord. This is a
This
case,
is
my
what
lord.
condonation of delay.
Condonation of delay of 394 days, my lord. This is a case, my lord, where the order has been passed, judgment has been passed, my lord.
Award is passed.
Award is passed, my lord. Can number. Sorry, can number is ekhane.
What is this can 2?
Can 1.
No, can 2 is for what?
Can 2 for appropriate order, my lord, and application for appropriate order, my lord.
No, section 5 application is served.
All are served, my lord.
So this is, you are challenging the quantum.
Quantum, my lord. I have challenging the quantum, my lord. He has not but taken the future prospect and all that, my lord. It is required, my lord. Lower court record is required. New India.
Yes, record an order. Yes, Mr. Singh, will you appear in this? Oh, you are appearing. Oh, in this next matter. Next matter, you are appearing. No, you have any objection with section 5?
I should take instruction, my lord. I don't know anybody has entered appearance or not.
Okay, then not this week. Come on the next day.
Kindly fix up a date, my lord.
It will appear under the heading application.
Application.
I am appearing on behalf of the appellant insurance company, my lord. There is no delay. This is a photocopy of the challan, my lord. I have deposited 25,000. In this also, my lord, I have the entire set of trial court records, my lord. The exhibits and.
Yes, record. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 10th day of April 2026, passed by learned Additional District Judge, First Track, First Court, Alipur, South 24 Parganas, in MSC case number 1320 of 2023 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation amount, including interest, as directed by the learned trial court, excluding the statutory amount, within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant shall cause service of notice both personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for and the informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
My lord, wherein my lord had stated award dated 10/4/2026, my lord. Along with that, it will be read with order dated 24/4/2026.
10/4/2026, read with
Order dated.
order dated 24/4/2020.
My lord, I'm deeply obliged, my lord.
I'm for the appeal. My learned is the appealing for the claimant.
My lord, I am for the claimant respondent. Caveat has been filed, my lord.
This is application for stay.
Only stay, only stay. This one copy of.
You are the sole claimant.
Yes, yes. Only injury case, my lord.
Okay. And
Okay,
service of, yes, record and order. Learned advocate for the appellant and learned advocate for the respondent number 1 claimant are present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 11th May 2026, passed by learned Additional District Judge, 5th Court, Barashat, North 24 Parganas, in MSC case number 41 of 2012 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount, within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. As the respondent number 1 claimant has appeared, service of notice upon respondent number.
Caveat has been filed.
You are for respondent number 1 claimant. Respondent number 1 claimant has appeared. Service of notice upon respondent number claimant is dispensed with. Stop.
My lord, respondent kindly dispense with the service of notice upon respondent number 2 also, my lord, since my lord, they only challenge is quantum of compensation.
Okay. The server, as the respondent number 2 did not contest the case before the learned trial court, service of notice upon respondent number 2 is also dispensed with. The trial court records be called for at the special messenger cost. The trial court records be called for at the special messenger cost to be deposited, to be paid by the respondent number 1 within 1 week. The informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
My lord, caveat number 2894 of 2026.
Yes?
Caveat has been filed.
Yes, you are the learned advocate for the caveator. Yes, I have recorded your presence. You are caveator respondent number 1.
Your Lordship, I'm appearing for the appellant insurance company.
Number 1 claimant, my lord. My lord, the
Item
74.
74.
My lord, this award was passed, my lord, against this appeal has been preferred, my lord, against an ex parte order. And against for vacating the ex parte order, my lord, the insurance company has already filed one miss case, which is pending.
that is pending.
Yes, my lord. Pending. This is the information slip.
Your Lordship, that doesn't preclude us from filing the
No,
appeal.
no, you cannot be exhaust in 2 cases. 2
Your
cases
Lordship,
you cannot.
Your Lordship,
Either you withdraw this or you withdraw that.
Your Lordship, the miscase which has been pending is pending in respect to the execution proceeding.
No.
My learned friend is
Kindly see, my lord.
My learned friend is
Yes, 518 of 2025 arising out of MSCC number 234 of
So
2025.
Lordship, that's a
the
code.
information slip.
Your Lordship, that my
When you, I am
instruction.
staying the proceedings.
Yes,
I am staying. I am not
and in the
staying this
meantime, I
appeal.
will take instruction. If
No,
there is,
There is conversion of delay also.
I am adjourning this matter for 4 weeks. Either you get that disposed or you
Your
will
Lordship,
here.
Your Lordship, they are extensively going against us
The
for the,
question is, have you filed any application for under Order 9 Rule 13?
Your Lordship, the application which has been filed in respect to the execution proceeding, Your Lordship, not in respect to the main petition, Your Lordship,
It is
because
not
that
possible, my lord.
because the judgment has already
In
been passed.
execution case,
You
there is
have
no
a
scope
copy
of
of the
filing any
miscase.
miscase.
You have
You
a
have
copy
a
of the
copy.
miscase.
You have a copy of the miscase.
My lord, at this moment, I don't have any.
Let me
Let
see
me
the
see, my
copy. Thereafter, I can ascertain.
Yes, Your Lordship.
So come next week, get a copy of that. case.
All right, all right. I will
The
bring. I
mean-
will bring the copy. my
Not
lord.
this week.
Not this week.
Your Lordship, the interim stay is required. Otherwise, they will proceed for the execution. That's why they are coming before Lordship today.
Why?
When is
As-
the next date? When is the next date fixed?
My Lordship, the next date is not
It
coming
also
week.
written, also
In
written.
this incoming week,
No,
Your
it will
Lordship.
remain in
Next
the
date fixed is, my lord, written is
That execution is there, Your Lordship. They are
Next date
coming
is, my
before you
lord,
today, before Lordship.
18/8.
18.
18/8.
18/8.
18th is the
Your
next
Lordship,
date.
they
So let it.
see the intention, Your Lordship, today. Today they are here before Your Lordship. We
Okay,
have
take on an
deposited the
order.
25,000 before your
Learned
Lordship
advocates
and-
for the parties are present in order to enable the learned advocates to obtain necessary instructions. The matter stands adjourned till 19/8/2026. Stop. As the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
Your Lordship, there is a delay that needs to be condoned before.
Anyway, first of all, you obtain instructions.
Yes, Your Lordship.
Passover 60 is the lordship.
Item
I know 60 lordship Passover.
you 77.
এটা কি জব? এটা কি?
So, come.
My lord, may I return back the information slip, my lord?
You want to take it back? Yes, take it back. Take it back.
Lordship, I know 60 is Passover matter.
60,
Passover
66,
60.
60. Yes.
Your Lordship,
What is this matter?
in this matter,
Section
Your
5.
No, there is the appeal. Most of it ready. I have prepared the paper book.
Your Lordship,
No, this
stay
is
needs to be-
this is any application which I
that
granted you
application that
liberty.
Stay is pending. That needs
No,
to
no.
be made absolute.
Okay, I have stay to be made absolute.
Yes, sir. We have deposited the entire sum. Your Lordship.
No,
application.
is it that matter why granted you liberty to take out necessary application for withdrawal?
That
Because you are praying for early hearing
Yes,
on
no.
the ground of urgency.
I have filed an application for withdrawal. That's true. That is in the pending. That
This
is-
matter.
Yes, but lordship, their appeal only on the ground that subject to submission of Mr. Ganguly, pay and recover. The observation is there, but ultimately not reflected in the ordering portion. Only to that extent the appeal filed. So lordship,
Now the question is how much is the awarded sum?
our is 4 lakhs, 4 lakhs for something.
4 lakh something.
Yes, lordship.
Now the question is, let your appeal be admitted, and in the meantime, they are praying for withdrawal of some part of the sum.
Lordship,
lordship-
my humble submission.
So how long? This is the matter of 2026.
Yes, Your Lordship.
Yes, but lordship claim case filed on 2019.
So claim case
Filed on
maybe, but this appeal is 2026. Then you can wait for some time.
Lordship, 2019. I am waiting for 2019.
There are persons waiting from 2012 also
Yes,
in this appeal court.
Kobe.
Your Lordship, there is a very only short point involved in this.
Okay, let me dispose this. Can 3?
Yes. Can 2, Your Lordship, first need to be disposed of?
Can 2 for stay?
Stay. The stay needs to be made absolute. There's a entire payment has been
Yes,
made.
they got learned advocate for the appellant and learned advocate for the respondent's number
Respondent number, lordship,
1 to 4.
1 to 4.
1 to 4 claimants are present. As the appellant has deposited the entire compensation amount, the ad interim order of stay granted earlier shall continue till disposal of this appeal. Service, there are 2 other insurance company, Cholamandalam and this vehicle owner. Oh, vehicle owner has to be served.
We have
We-
served, Your Lordship.
Service is complete.
Yes, sir. Sir, Your Lordship, kindly see
And
the first.
Cholamandalam?
No, I am the Cholamandalam.
Oh, right.
He is
No, no, you are the
That-
appellant.
That's the court, Your Lordship.
Okay, okay.
That's the court application.
Okay. The paper books are ready.
Yes, lordship, almost ready. And I have served also.
Almost ki di da.
As the paper books are ready, LCI, TCR has come.
It is not required because of.
Oh, why not required? So many points are arising.
No,
without
Lordship,
verification of
here
the.
both are present, Lordship.
Your presence will not do like that. Trial court records are necessary.
Lordship,
Acha,
yes,
let-
all the certified copy I have.
The paper books, many, you see, most of
Lordship,
the time I
only
see
please this,
some.
only please this. Huh? So LCR is there, TCR is there, Lordship.
Trial court record essay. Acha, as the matter is ready for hearing and the trial court records have come, let this matter appear for hearing on. Dekhun to.
Lordship, the only please the pay and recovery. The other part I am not touching. Only my, as you court I have filed, court
Just a
number
minute.
36 of 2026.
9 September আর অন্য কোনো ম্যাটার ফিক্স নেই তো 2026 at 3 p.m. or at 12 p.m.
Lordship, the paper who filed kept with the record.
Paper books file be kept with the record.
Lordship, another please that I have filed a cross objection, kindly to tag with the cross objection.
Acha,
36 of 26.
let the cross objection
36 of 26.
36
Huh.
26 be listed along with this case. এই এটা কোন ম্যাটারের ইয়ে দেখো এই যে
In this matter. In this
না না এই
matter.
যে স্ট্যাচুটরি ডিপোজিটটা 16
No, no, this matter, Mr. Ganguly filed this matter.
না যেটা অ্যাবসলিউট হয়ে গেল ওটা ডিসপোজ ক্যান টু হ্যাঁ ক্যান টু হ্যাঁ
I am for the respondent, my lord.
Take one.
yes
My lord, this is the appeal of insurance company. The main issue which involves in this appeal, my lord, is
yes
my lord, is whether the insurance company would be liable in case, my lord, the premium check is being dishonored. My lord, my client has come up before your lordship, my lord, to pray for absolute exoneration.
yes
That is an accident of 2005, 25th June 2005.
yes
My lord, a pillion rider on a motorcycle was killed. Learned tribunal judge, my lord. She was a lady, my lord. Learned tribunal judge, my lord, awarded rupees 1,87,000. 1,87,000.
25/7/2005
25/6/2005 is the date of accident.
yes
My lord, learned tribunal judge awarded, my lord, rupees 1,87,000. with 9% interest in a proceeding under 163 capital A. Following the schedule, my lord.
1,87,000
with 9%. My lord, award is dated 20th May 2006.
Yes.
My lord, now, in view of the point, my lord, what I had taken, my lord, I would invite your lordship, my lord, to come to the award passed by the learned tribunal judge, my lord, how this issue has been dealt with. My lord, the award of learned tribunal starts at page number 9. My lord, the paper book, my lord, my learned friend prepared the paper book. I'm thankful to him, my lord.
163A.
Lordship. My lord, is my lord at page number 9 of the paper book, my lord.
Page 9.
Lordship. My lord, that is where, my lord, the award passed by the learned tribunal starts.
Yes.
My lord, is my lord there, my lord, page 9. My lord, top fourth line, your lordship will kindly see MSCC number 84 of 2005 under section 163A. And my lord, the award starts judgment in the middle. The present claim application is initiated by petitioners by Sujit Leland Saha for himself and on behalf of his minor children under section 163A. So, my lord, this is clear. My lord, your lordship will kindly come, my lord, to the next page, page number 10. Is my lord there?
Yes.
My lord, starting from the top. The OP number 2, United India Insurance, has contested the case by filing written statement stating that insurance company was not insurer of the alleged motorcycle. It was a motorcycle, bearing registration number so and so at the time of accident because the insurance policy was cancelled by the OP number 2 as the check given by the OP number 1 for payment of premium was dishonored and returned by the bank for insufficiency of fund. So, my lord, it is clear in the written statement the plea has been taken, which has been taken out of by learned tribunal judge. My lord, now this issue has been dealt in detail, my lord, from page number 12 onwards. Internal page 12 of the internal page 4 of the award, running page 12 of the paper book.
Yes.
This, my lord, answer.
Yes.
Running page 12, my lord.
Yes.
Second paragraph, starting with the petitioners also. The petitioners also filed copy of insurance certificate which shows that the offending motorcycle was insured with insurance company from 9th February 2005 to 8th February 2006, which includes the date of accident, that is 20th June 2005. Now, my lord, it is submitted by the learned advocate for the insurance company, OP number 2, that the offending motorcycle was not insured at the time of accident, as the said insurance policy was cancelled by the insurance company. The insurance company examined one witness as DW1, who is an employee of the United India Insurance. In his evidence, he stated that one insurance certificate was issued in favor of OP number 1 owner, Sontu Kumar, who gave a check towards premium which was dishonored. He received the notice from the bank as the check was dishonored due to insufficiency of fund. The bank informed them regarding such dishonor of check by sending a letter. You know, them means insurance company. Thereafter, they informed Sontu, that is the owner of the bank, owner of the motorcycle, by issuing a letter that his policy was cancelled. They also sent the copy of the letter to motor officer, that is RTO. They also sent letter by registered post to Sontu as well as to the RTO. It is submitted by the learned advocate for the insurance company that the evidence of DW1 as well as the service of documents Exhibit A series is well established to show that at the relevant time of accident, it was not insured under the OP number 2. As such, at least the OP number 2 is not liable to pay any compensation. Lord, the dates were given, my lord, the references were given, Exhibit A series, page 13. Learned advocate for the petitioner, on the contrary, has strongly opposed the contention.
Legal owner did not appear.
No, owner did not appear. Advocate for the petitioner, on the contrary, has strongly opposed the contention of the learned advocate for the opposite number 2 and also submitted that OP number 2, that is insurance company, is bound to pay compensation to the petitioner as the cancellation of the policy due to dishonor of check would not affect the rights of third party, which was occurred on the date of accident. The decisions were cited. Next parameter. However, considering the matter, I have carefully perused the entire materials on record and the documents filed on behalf of the OP number 1, as well as the decisions cited by the OP number 2. OP number 1 and decision cited by OP number 2. OP number 1 ta ke ache?
The vehicle owner.
Vehicle owner. Yes. Yes. OP number 1 as well as the decision cited by the OP number 2, that is insurance company. And it appears to me from the Exhibit A series that the one insurance certificate was issued on behalf of OP number 1. There is some confusion because this insurance certificate was issued by OP number 2.
Yes.
After accepting
OP number 1.
To OP number 1. Grateful to your lordship. After accepting the check from him.
Documents filed on behalf of OP number 1.
Lordship, these were filed on behalf of OP number 2 because OP number 1 has not filed any document to the best of my knowledge.
On behalf of OP number 1.
It should be read as OP number 2, I believe. Because OP number 2 is the insurance company. Lordship will kindly come to page number 15 for clarification. Page 15.
Yes.
Award that the MSCC is hereby allowed on contest without cost against the OP number 2, United India, and ex party against the rest. So, I am OP number 2. And this is also reflected, at page number 9, the cost title of the award. I am OP number 2. So, perhaps it was ex party against the owner. Somehow, there are some typographical errors which have crept in. I was at page number 12. It is submitted by the third paragraph. It is submitted by the learned advocate for the OP number 2 that the offending motorcycle was not insured at the time of the accident, as the said insurance policy was cancelled by the insurance company. The OP number 2 examined one witness as DW1, who is an employee of United India Insurance. In his evidence, he stated that one insurance certificate was issued in favor of the OP number 1 shown 2, who gave a check towards premium which was dishonored. He received
that is paragraph number?
I am at page 12. My lord is at page 13,
Yes, 13.
I am sorry, I'll come back to 13. 13, second paragraph. However,
yes.
However, considering the matter, I have carefully perused the entire materials on record and the documents filed on behalf of the OP number 1 as well as the decisions cited by OP number 2 insurance company. And it appears to me from the Exhibit A series that one insurance certificate was issued on behalf of or in favor of, it should be in favor of OP number 1 by OP number 2 after accepting the check from him. But as the check was dishonored for insufficiency of fund, the OP number 2 cancelled the insurance policy and informed regarding such cancellation to OP number 1 as well as to the RTO. However, in spite of that, relying upon the settled principle of law as well as the decisions cited by the learned advocate for the petitioners, I am of the view that the policy of insurance issued by OP number 2 was relevant, upon which the authorities and third party were entitled to act. Subsequent cancellation of the said insurance policy is not concerned with the third party, and the subsequent cancellation of policy due to dishonor of check would not affect the rights of third party, which had occurred on the date of accident. And the OP number 2 cannot fix his obligation to third party under the policy, because it did not receive the premium. As such, relying upon the settled principle of law, I am in a view that it is obvious that the OP number 2 insurance company, being the insurance company who issued the policy in favor of the OP number 1, is duty bound to pay the compensation. However, Your Lordship will take note, he is at liberty to realize the same afterwards from the OP number 1 in a separate proceeding. Lord, it says, Lord, that since the policy has been issued, its subsequent cancellation would not be taken into effect as far as the third party is concerned, but insurance company is at liberty to recover the money from the owner of the vehicle. This is what, Lord, it is here at page number 14. Thereafter, Your Lordship will kindly come to page number 15, the award. Lord, this is, Lord, only in reference to the issue, Lord, what I am raising. Page 15, award, Lord.
Yes.
MSCC number so and so is hereby allowed on contest without cost against United India. The petitioners do get an award of rupees 1,87,000 only from the opposite party in equal shares under 163A. Opposite party number 2, United India, is directed to pay to the petitioner in equal share within 2 months from the date, failing which, my lord, 9% interest. My lord, initially no interest, but in default 9% interest from the date of filing, that is 29/1/2005 till final realization. The petitioner Sujit is permitted to receive checks which will be issued by the insurance company in his name as well as in favor of his minor children. Petitioner number 1 is also directed to keep the shares of the minors in any nationalized bank or post office, minors till minors attain majority, and to file photocopies of the deposit certificate in court within 1 month. Let a copy of the judgment be handed over. But in this ordering portion, this pay and recovery part is perhaps, has been omitted or perhaps has been missed out. The easiest thing today would be, before your lordship is to, your lordship will kindly grant me recovery right, let them take the money. This would have been perhaps the simplest of answers today to get this matter disposed of within 2 minutes. I wouldn't even have to read this thing. But I assail this award on the point, when the insurance premium has not been received. There is an acknowledgement and admitted fact by the learned tribunal judge that intimation has been given to the owner of the vehicle who had issued the insurance check. He has received that intimation. Intimation was also given to the RTO. That is also admitted fact. So when insurance company did not receive any premium, when insurance company did its part of job by informing the owner that your premium check has been bounced, it also informed the RTO that, see, my lord, your lordship kindly remembers, in one case your lordship said, we should also intimate the RTO. Here in view of Supreme Court judgment also, insurance company intimated the RTO also that insurance premium has not been accepted, has not been given, and subsequently also
how uninsured vehicle can come to the road? That is the question.
That is for the owner to decide, and that is for the police to decide. Your lordship will take them to task.
I've clarified that.
I have my vehicle. My vehicle today, yesterday the insurance period expired. I take it out. Who will stop me? Who will go to my home?
No.
And who is the authority to check it up?
No. I directed the insurance company to immediately, if the...
this is the case of 2005.
Anyway, this is an old matter.
2005. So, even assuming, today, insurance company has got, lakhs and lakhs of vehicles insured under it. My lord is putting this onus upon the insurance company to every day decide throughout the country how many vehicles insurance coverage are aspiring today. Today we are on 13th of August.
Every day the validity period expires.
Yes.
The moment the vehicles are renewed, the matter ends.
The
moment it is not renewed.
The moment it is not renewed, now today there are roughly 30 insurance companies, including private and the nationalized companies. We do not know, one insurance company does not know that the motor vehicle owner, like my learned friend, he chooses which of the other 29 companies.
Anyway, that is for the authority to see. Authority will
authority means
regional transport authority. The moment the police authority get intimated, they will see, they will go, they will intimate the vehicle owners.
When will I intimate? Today, till yesterday, his vehicle was insured with me. Today, he is not renewing his insurance coverage. I have to check up
immediately on the following day itself.
Throughout the country. Then, I have to segregate those insurance policies which had expired today and which have not been renewed today.
Anyway, at best, it can be on the following day.
At best, it can be on the following day. And then when will it go? It reach to the RTO?
Immediately thereafter.
1 week, 2 weeks, 10 days, 15 days. And when will they react? It is for them to react.
That is a specific direction upon the Transport Secretary, the Director General of Police, as well as to take necessary steps
to confiscate.
Anyway, so that the vehicle does not come on the road.
My lord is absolutely correct. To confiscate, so that vehicle does not come on the road.
Yes.
And last fortnight, at the cost of repetition, I say Supreme Court, is so furious and it is so frustrated that 56% of the vehicles on Indian roads are running uninsured. Supreme Court has taken note of perhaps my lord's order. Maybe.
No, because order is confined to state of West Bengal. I cannot extend it to all over India.
The principle, what I say, that when the vehicles are running uninsured, what to be done?
Anyway, it is high time.
It is high time. This is the case of 2005. insurance company, to the best of its ability, inform the insured that you see your vehicle, which you gave the premium check, it has bounced. Your vehicle is now not insured. You should take note of this.
Earlier, these vehicle owners were not very serious, but probably now
Now
they have taken
56
it seriously.
now 56% are uninsured. They in 2026 should
Anyway, slowly they will come to. They will be aware.
we all
The moment they are settled with this obligation, they will be aware.
we all pray that every vehicle should be insured. This is
Yes.
the ideal situation should be. But knowing the people of our country,
The machinery.
knowing the machinery, knowing the
check.
police, but police, insurance company would inform the police, insurance company would inform the RTO, and when they will come, when they will confiscate, it is very difficult.
Actually, you
Point
see,
is,
the moment the letter goes to the insured with a copy to the police authority and the RTO, they will be aware that
They
anytime the vehicle.
they will be aware.
The moment that notice says that copy
Yes,
to so and so.
they will be aware. What would they do? They would confiscate the vehicle.
No. The moment either they have the choice not to ply the vehicle or to get the insurance.
Owner chooses to ply the vehicle without being insured.
Now you see,
It is the owner has taken upon himself to ply his vehicle in spite of knowing the fact that the vehicle is not insured.
now the time has come. Definitely, you see, the moment these reminders will be given, they will be aware.
This is the owners, and this is the burden upon the RTO, and this would be also on the police authority. Already, the way they are functioning, your lordship knows, now giving notice to each and every individual, the vehicle owner, that you come and show whether you have renewed your vehicle's insurance coverage or not. I do not know how it is possible, but I wish sincerely hope, that this happens, and all vehicles are running on. Tomorrow I may suffer injury. Any one of us can suffer injury, in the motor accident. And if the accident occurring vehicle, the vehicle which is committing the accident is uninsured, where would we land up? We all face this dichotomy, we all face this problem. And that is why, we are here before your lordship. And that is why, unless owners are taken to task, this menace would not go out of our society. The one who is committing the fault, he is running away. That is why, I always beseech your lordship, to take them to task. The one who is committing the offense should not be allowed to go scot-free. Here, owner knows that the vehicle is not insured. He is running the vehicle.
I have delivered judgment on this view.
Yes.
I shall deliver that judgment.
In this case, I'll go a step further. Because, in this case, there is evidence that the insurance company has informed, the vehicle owner, who, in spite of knowing, is still plying the vehicle. And insurance company has also informed RTO. That is what the finding is.
Is still your client, this person?
No, today 2026, whether after 21 years motorcycle would exist, I do not know. The only thing, whether insurance company in these cases can be, made liable to make payment and then to recover or not. Recovery right would be there. No issues about that. But I am saying, when I have done my part of job, when I fulfilled my duty, then in this case, insurance company should be exonerated and the owner should make payment. And that is what the intention of Supreme Court had been throughout. May I just, now, show, the evidence of, the insurance company's officers, then I'll place those judgments, the evidence of the officer of the insurance company, is at page number 23.
Yes.
Page 23. In this context, what Supreme Court has said, since my lord had indicated this, that the officers should be intimated and RTO should be intimated. That's what my lord's order was, Supreme Court, your lordship kindly remembers, a few years back, had given a general order that every single petrol pump in the country should not give the petrol to the two-wheeler owners or the two-wheeler drivers or the riders who are without helmet. Who is following that in the country? Nobody. No, not even one, including those, who are in the High Court area. This is number one. The last fortnight, what I refer to, Supreme Court has said again that it is also the onus upon the petrol pump, owners, when they are giving petrol, to see to it if the vehicle is uninsured, then not to give petrol pump. Honorable courts are coming out with these, statements and with these directives, but how far they are being followed? There is a direction: without helmet, no petrol. without insurance coverage, no petrol, but whether those are being followed, those who are, my lord, not following the law, my lord, they should be punished. It is as simple as this. There is, my lord, no, my lord, rocket science in this. And in this case, what I say, that the owner who knowingly, deliberately, without insuring his vehicle, was plying his vehicle and he killed somebody, or because of his fault, somebody got killed, he should be penalized. My lord, may I just give the, my lord, evidence part, my lord, what my insurance company has stated before the court. That was at page number 23. My lord, what is the fault of insurance company? Why insurance company should be penalized without even receiving the premium? Page 23, my lord, the deposition of witness DW1 for the respondent, aged 30, is my lord, at page 23. My lord is at page 23, my lord.
23.
I'm grateful to your lordship. Lord, my name is Sri Shoibal Bhomik. My father's name is so-and-so. My home is at this. I am the employee of United India. I am posted at Himalaya House, so-and-so. I am the assistant manager. I am posted here since so-and-so as an assistant manager. Next para. Shontu Kumar, my lord, he is the owner of the motorcycle. Shontu Kumar Sardar filled up a proposal form of insurance certificate and also gave a check for premium of insurance, which was dishonored. I received notice from the bank as the check was dishonored due to insufficient fund. This is the return check of Shontu Kumar, Sentu Kumar. The bank informed us regarding the dishonor of check by sending a letter dated 10th March 2005. The date of the check is 8th March 2005. Without accident is 25th June. It is happening 3 months before that. He deposited the check on 8th March 2005 before the United Bank of India. Sentu Kumar also issued the check of the same bank. The banker of the insurance company and this insured were same, United Bank. Thereafter, informed Sentu by issuing a letter that his policy was cancelled. This is the copy of the said letter. He sent the letter on 11th March, or we sent the letter on 11th March, 3 days prior to the date of accident.
Yes.
This letter became the signature of motor vehicle officer Sushanto Ghosh. I know his signature. We sent the letter by registered post with AD. I am filing the AD card in court today. We sent a letter to the RTO by sending a letter dated 11th March that the policy of Sentu Sardar was cancelled by registered post. This is the copy of the said letter. It also bears signature of Sushanto Ghosh. Thereafter, we issued endorsement on 11th March. All these are happening more than 3 months before the date of accident. We issue endorsement on 11th March for cancellation of policy. This is the copy of that endorsement. This endorsement also bears signature of Sushanto Ghosh. Sentu Sardar gave premium for insurance certificate in connection with the motorcycle. We issued receipt in favor of Sentu after receiving the check. There is the copy of the receipt. It is specifically mentioned that receipt will be valid subject to realization of the check. This is the duplicate of that receipt which was obtained from the computer. Check amount ultimately was not realized. As the policy was cancelled, Sentu is not our policy holder at present. Malad asked this question, Malad, whether subsequently it was done or not. So Sentu is not the policy holder at present. We mentioned in our WS regarding the cancellation. In cross, insurance is a contract in between insurer and insurer. Insurer is the first party and insurer is the second party. I have not brought the proposal form. Such vehicle has single chassis number and engine number. Engine number is so and so.
No, this is
Period
okay.
of
This is a cross-examination.
Is this cross-examination?
By the claimant.
By the claimant, yes. Owner was not there, so by the claimant. Payment of premium is not the concern of third party. I am aware that dishonor of check for the cancellation or policy could not affect the right of third party, which was approved by the motor accident. Right, my lord? Third party should not be made to suffer. The only point is who would make payment. I have cancelled the policy. I have informed the insured. I have informed the RTO. Court acknowledges that the evidence is there. There is no dispute with regard to this. After this acknowledgement, after this affirmation, after this acceptance, whether insurer can be made liable or not, the learned tribunal just said that no, you pay and then you recover. But this recovery part, my lord, was not mentioned.
Not in the operative part.
It was not in the operative part. But my lord, I say, my lord, I should not be asked to pay. Now, my lord, I have made, my lord, as far as the facts are concerned, my lord, I have clarified this position. My lord, now, my lord, I'll rely upon the judgments. My lord, what Supreme Court is saying. My lord, first one, my lord, of 2008, in these references, my lord, 2007. There were earlier judgments, my lord. I'll not trouble. I'll give, my lord, last three important judgments which had considered, my lord, the earlier Supreme Court judgments, my lord, 2007, 2012, and 2025. 2007, my lord, first of all. Dedappa. 2007 Dedappa. এটা 2012 কেন দেখছো বারবার? এটা Lordship. My lord, these are all these are premium check, my lord. Relevant part, my lord, paragraph 17. 17 onwards, my lord.
Yes.
We may Dedappa, Dada. Dedappa versus National. Dedappa versus National লিখে নাও, এটা মানলেই পেয়ে যাবে। 12/12/2007. Below paragraph 17, my lord. We may, however, notice that in terms of section 5 of section 147 and subsection 1 of section 149 of the Motor Vehicles Act,
Yes.
the insurance company became liable to satisfy awards of compensation in respect thereof, notwithstanding its entitlement to avoid or cancel the policy for the reason that check issued for payment of premium thereon had not been honored. The said question, however, was left open in Inderjit Kaur case. 19. The said decision proceeded on the basis that it was the insurance company which was responsible for placing itself in the said predicament, as it had issued a policy of insurance upon receipt only of a check. You know, it is referring to Inderjit Kaur's earlier judgment of a check towards the premium in contravention of the provisions of section 64 VB of the 1938 Act. The public interest in a situation of that nature and applying the principle of estoppel, this court held, would prevail over the interest of the insurance company. Therein, court said insurance company, you should make payment because you had issued the policy. It has been referred to here, in the past judgment. 20. The ratio of said decision was, however, noticed by this court in New India versus Rula. It was held that ordinarily a liability under the contract of insurance would arise only on payment of premium. If such payment was made, a condition precedent for taking effect of the insurance policy, but such a condition which is intended for the benefit of the insurer can be waived by it. It was opined on the date of accident, there was a policy of insurance in respect of the vehicle in question. The third party would have a claim against the insurance company, and the owner of the vehicle would have to be indemnified in respect of the claim of that party. Subsequent cancellation of the insurance policy on the ground of non-payment of premium would not affect the rights already accrued in favor of the third party. Therein it was the subsequent cancellation. In our case, it is not the case of subsequent cancellation. 3 months before the accident, we have cancelled and we have informed everybody. The dicta laid down therein clarifies that if on the date of accident the policy subsists, then only the third party would be entitled to avail the benefit thereof. 21. Almost an identical question again came up for consideration before this court in the case of Seema Malhotra. A division bench noticed both the aforementioned decisions and analyzed the same in the light of section 64 VB. Section 64 VB, it is referred here. 64 VB, it speaks that
Under the old act.
It is Insurance Act 64 VB. It says, unless the premium is received by the insurance company, there would be no policy. A policy would come into the force, in lucid language, I am saying the policy would come into force only when the premium is received. No premium, no policy. Come what may. So that is why 64 VB of 1938 Act. This is not the Insurance Act. Then paragraph 21 has been quoted. Then I'll invite your lordship to paragraph next page or the page after next last page, paragraph 26. The last page of this judgment. Paragraph 26. The judgments, earlier judgments were referred to, quoted, and the finding part. We are not oblivious of the distinction between the statutory liability of the insurance company vis-a-vis a third party in the context of section 147 and 149 of the Motor Vehicle Act, and its liabilities in other cases. But the same liabilities arising under a contract of insurance would have to be met if the contract is valid, if the contract of insurance has been cancelled, and all concerned have been intimated thereof. Intimated. Lordship will kindly take note. Intimated thereafter, we are of the opinion the insurance company would not be liable to satisfy the claim. Lord, it is as clear as water, my lord. 27, a beneficial, Lordship will take note of this 27 as well. A beneficial legislation, as is well known, should not be construed. Is my lord on 27, my lord?
Yes.
27. A beneficial legislation, as is well known, should not be construed in such a manner so as to bring within its ambit a benefit which was not contemplated by the legislature to be given to the party. This is very important sentence, my lord. Just because under the garb of beneficial legislation, my lord, a benefit cannot be given to the person which was not intended by the legislature. My lord, pausing here for a moment, my lord, I'll just indicate also, my lord, now the act has been amended from 2022. My lord knows that. My lord, section 164, 5 lakh. Your my lord is taking, my lord, assistance of that section also. In the 164, my lord, in by way of the amendment, my lord. In the new amended act, my lord, there is a specific provision, my lord, the insurance company has got this statutory defense with regard to, my lord, the premium check being bounced. So, my lord, when the policy does not exist because of premium not being received, which was not there in the earlier act, in the 1988 act. So now Parliament has thought it fit, my lord, that make it a statutory defense of the company when there is no premium. Forget about giving intimation. Nothing, no intimation. You have not received premium. There is no insurance policy. It is as clear as that, my lord. Now it has come to. But, my lord, I am also interpreting the earlier judgments wherein it was made clear that not only not receiving the premium, you have done your job by intimating. That intimation you have done, then you are not liable. That is the specific line of paragraphs 26 and 27, what I have stated at the cost of repetition. A beneficial legislation is well known, should not be construed in such a manner so as to bring within its ambit a benefit which was not contemplated by the legislature to be given to the party. In my lord's regional director, so and so, this court held. We do not doubt that beneficial legislation should have liberal construction with a view to implementing the legislative intent. But where such beneficial legislation has a scheme of its own, there is no warrant for the court to travel beyond the scheme and extend the scope of the statute on the pretext of extending the statutory benefit to those who are not covered by the scheme. So, paragraph 28. 27, we therefore agree with the opinion of the High Court. 28, however, as the appellant hails from the lowest strata of society, we are of the opinion that in a case of this nature, we should, in exercise of our extraordinary jurisdiction under 142. My lord, 142 has been invoked. Direct the respondent number 1 to pay the amount of claim to the appellant and recover the same from the owner of the vehicle, particularly in view of the fact that no appeal was preferred by him. My lord, in this case,
Yes.
Absolutely clear holding, insurance company is not liable if insurance company does its part of job. On the garb of social beneficial legislation, my lord, the benefit cannot be extended. But Supreme Court said that we are in this particular case, we are using 142 and we say that you pay and then you recover. Here also, my lord, there was no specific evidence, my lord, that the notice and intimation was given prior to the date. Still, Supreme Court said that the insurance company is not liable, not to pay, but we are using 142. This is, my lord, 2007. Dedappa, not to pay. Then, my lord, 2012, my lord, Lakshmama. United India versus, my lord, Lakshmama. Same point, my lord, check bouncing, premium check dishonored, whether insurance company becomes liable to pay or not. My lord, I will state, my lord, invite your lordship, my lord, to paragraph 19. Instead of, my lord, taking, my lord, here and there of the facts. Paragraph 19, my lord. Last but one page. Last but one page, my lord, at the bottom, paragraph 19. My lord is there, my lord. It has taken note of all earlier judgments, including the Dedappa. And prior to that, Sima, Indrajit Kaur, all others. Then, my lord, what is the outcome in paragraph 19? In our view, the legal position is this.
Para 19.
Oh, yes, my lord, 19. Last but one page, my lord.
Under section 25 of the.
No, my lord, your lordship will come, my lord, last but one page. My lord, that was the internal paragraph 19. My lord, I'm running paragraph 19, my lord. Last but one page, my lord, penultimate.
Yes, in your view.
I'm grateful to your lordship. In our view, my lord, the legal position is this. Where the policy of insurance is issued by an authorized insurer on receipt of check towards payment of premium, and said check is returned dishonored, the liability of authorized insurer to indemnify third party in respect of the liability which that policy covered subsists, and it has to satisfy award of compensation by reason of provision of section 147(5) and 149 of the Motor Vehicle Act, unless, your lordship will kindly take note now, unless the policy of insurance is cancelled by the authorized insurer, an intimation of such cancellation has reached the insured before the accident. My lord, in this case, we have done so. That has been taken note of and acknowledged and admitted by the learned tribunal judge. In other words, where the policy of insurance is issued by an authorized insurer to cover a vehicle on receipt of the check paid towards premium, and the check gets dishonored, and before the accident of the vehicle occurs, such insurance company cancels the policy of insurance and sends intimation thereof. It only sends intimation. You forget about receiving. Sends intimation thereof to the owner, the insurance company's liability to indemnify the third parties which the policy covered ceases, and the insurance company is not liable to satisfy awards of compensation in respect thereof. Again, my lord, it's absolute clear. Its liability ceases, and it cannot be asked, my lord, or forced to make payment of compensation. Paragraph 20, my lord, next. May I read, my lord?
Yes.
Having regard to the above legal position, in so far as facts of the present case are concerned, the owner of the bus obtained policy for the period April 16, 2004 to April 15, 2005, for which premium was paid through check. On April 14, accident occurred on May 11. My lord, 1 month after the policy being taken, accident occurred. It was only thereafter that insurer cancelled the policy. In this case, my lord, the policy was cancelled after the accident. Insurer cancelled the policy by communication dated May 13. May 11 accident, May 13, my lord, intimation given after the accident on the ground of dishonor of check which was received by the owner of the vehicle on May 21, much after the accident. The cancellation of policy having been done by the insurer after the accident, insurer becomes liable to satisfy the award passed in favor of the claimant. My lord, since in this case, my lord, the intimation was sent after the accident. That is why, my lord, the Honorable Supreme Court said that you pay, and still the recovery right is granted. Last paragraph. In view of the above, the judgment of the High Court impugned in the appeal does not call for any interference. Civil appeal is dismissed. However, the insurer shall be at liberty to prosecute its remedy to recover the amount paid to the claimants from the insured. But here also, absolutely clear, you give the intimation before the accident, you are not liable. In this case, it was found intimation, my lord, was sent after 1 month after the accident, my lord. So it said, okay, you pay and then you recover. But if you have given the intimation prior to the accident, my lord, this judgment again follows the Dedappa, and my lord, taking note of all other judgments, my lord. My lord, I have not gone through, otherwise, my lord, it would take a lot of my lord's time. But all other references have been taken note of, considered, and my lord, finding reached. Now, my lord, again, leaving aside, my lord, in between the other judgments, my lord, I'll straightway come, my lord, to the very latest and the last judgment on this issue in 2025, Sunita. Dada, note kore na? National versus Sunita. Again, my lord, the same check bouncing issue, my lord. All earlier judgments have been taken note of, considered, including Dedappa, including Lakshmamba, earlier Indrajit Kaur, Rula, all. Then, my lord, I would invite my lord, to come to paragraph 4. Page number 2, paragraph 4. Is my lord there, my lord?
Yes.
Emphasizing the aforesaid finding on record that the check was dishonored and the intimation was given by the appellant insurance companies, learned advocate Mr. So-and-so, appearing for the appellant insurance company, submitted by relying on the decision of this court in Seema Malhotra, that when the insured had failed to pay the premium promised and the check towards the premium returned dishonored by the bank, the insurer was not liable. Lord, I have not given Seema Malhotra, Lord, I have not burdened your lordship it further. 4.1. Learned advocate for the appellant proceeded to press into service other two decisions on the line in Dedappa. Lord, I have given your lordship the Dedappa. And United India versus Lakshmamma. Lord, I have also given your lordship Lakshmamma. To submit that when the position was clearly obtained that the premium was not paid and the communication was sent in that regard to the concerned parties, the tribunal and the High Court both committed an error in directing the appellant company to pay the amount of compensation to the claimants, although to permit the appellant to subsequently recover from the owner. It was submitted that the appellant insurance company was required to be entirely exempted from liability to deposit or to pay. Milord, next paragraph, Milord. On the other hand, learned advocate for the claimant, Mr. So-and-so, submitted that judgment and award by the tribunal and upholding thereof by the High Court requiring payment of compensation to the claimants by the insurance company was just and proper, and such direction was in the nature of doing justice. He submitted that insurance company has already deposited 50% of the awarded compensation along with interest, and the claimants have withdrawn the same. Lord, in this case, insurance company, while granting stay, Honorable Court asked insurance company to pay 50%, and that 50%, by the time it came for final hearing, was already withdrawn by the claimants. 50% of the amount. In this case, this, the Sunita Devi, what my lord is, taking note of. Paragraph, next paragraph 5. In Dedappa, this court addressed very point interpreting the provisions of section 147(5), 149(1), 166 of the Motor Vehicles Act in relation to the liability of the insurance company vis-a-vis the third party in the eventuality of rescindment of insurance contract on account of non-payment of premium because of bouncing of check issued towards premium amount. In that case, check dated 1997 was dishonored on 21st October 95 due to insufficient funds, upon which the respondent insurance company cancelled the policy and informed the vehicle owner as well as the RTO. This court held that the contract of insurance stood rescinded due to failure of consideration and intimation to that effect given to the parties concerned. However, the court in exercise of jurisdiction under Article 142 of the Constitution directed the insurance company to compensate the appellant and to recover. In the first case, that is referred to. 5.2, the subsequent judgment in United, that is the Lakshmamma, laid down the very principle that the statutory liability of the insurer to indemnify the third parties would subsist unless the insurance policy was cancelled and the intimation of such cancellation has reached the insured before the accident. In this judgment also, the court reiterated, the principle was laid, you inform, then you don't have to pay. If the information is subsequent to the accident, then pay and recover. Recovery right is always there. There is no confusion. But if you inform beforehand, then don't pay. Paragraph 5.3, adverting to the facts of the present case, it is to be noticed that the accident took place on August 25. The check towards premium was dishonored and intimation was given with a letter dated 4th May 25. Identical to our case?
Yes.
4th May 25, premium intimation given, accident on August 25. Absolutely akin to our case. Therefore, there was a gap of more than 3 months from the date when the insurance policy was liable to be treated as cancelled and the date when the accident took place. The High Court in its judgment, while confirming the judgment and award of the claims tribunal, appears to have taken the view that the insurer, having admittedly issued the insurance policy against third-party risk, the rights of third party would not get affected when the policy was issued, and in that light, insurer must satisfy the award in favor of third party by protecting the rights of insurer to allow it to right of recovery. In this case, the Sunita's case, High Court granted pay and recovery right. Para 5.5, from the facts on record and more particularly in view of the decisions of this court in Dedappa and United India, that is Lakshmamma, it could be immediately seen that even as this court has underscored the proposition that cancellation of insurance policy issued in favor of the third party for covering third party risk because of bouncing of check for premium or non-payment of premium would in law absolve the insurer from liability to pay the compensation, once the insurer has intimated the cancellation to the parties concerned in the final directions issued, the court thought it fit to direct the insurance company to make payment of compensation to the claimants and thereafter to permit to recover the same. 5.6. It is to be noted that at this stage, that pursuant to the order dated July 27, passed by this court, in the present proceeding, appellant insurance company has already deposited one half, that is 50% of the awarded compensation with interest, and the claimants have withdrawn the said amount. In Sunita's case, not what we are reading. 5.7. Depositing of the compensation amount by the insurance company as above could be well said to be confirming the law laid down by this court in Dedappa and in Lakshmamma's case. Insurance company has deposited the 50% of the compensation with interest as awarded. The same is also released. And the respondent claimants have received them in larger interest of justice to all parties. Milord, 50% they have already received. Then, Milord, parties, no recovery deserves to be permitted for the said amount deposited and withdrawn from the claimants. Insurance company says that once the claimants, Milord, they have taken out, already taken that money, now don't proceed against the claimant for recovery of that amount. 50% what the claimant. Next line, it would be only farce but would amount to setting the clock back since they have already taken. Now, Milord, the important part, paragraph 6. In the totality of the operative facts, this court is of the view that 50% amount which is already paid to the claimants need not be touched. Therefore, it is provided that there shall be no recovery from the claimants in respect of the said 50% part of compensation. The appellant insurance company, however, shall be at liberty to recover the said 50% amount along with interest deposited by it as above and received by the claimants as above from the owner of the offending vehicle in accordance with law. Milord, since that was already given to the claimant, Milord, Supreme Court said, let's not put the clock back. Claimant have received 50%. Insurance company, you take this 50% from the owner. Now, Milord, the clinching line, the last sentence. As far as the balance of 50% amount, you also will kindly make a mark. As far as the balance of 50% amount along with interest is concerned, which remains, which is still due, Milord, the claimants shall be entitled to recover the same from the owner of the offending vehicle in accordance with law. And this is the last word of the Supreme Court on this. Insurance company not to pay. The entire money is to be paid by the owner. And it has considered all earlier judgments, and two of which Milord have been very specific. Milord, the cost of repetition, Your Lordship will kindly pardon me. Insurance company has been asked to not to pay, not to pay, not to pay. Once you give the intimation before the date of accident, and in our case, Milord, I have read it, the line, Milord, on the number of occasions that the learned tribunal judge has acknowledged that yes, 3 months prior to the date of accident, insurer has intimated, Milord, to the owner as well as to the RTO. The evidences were produced. The officer of the insurance company came before the court. He gave a specific evidence. So, Milord, in the totality of the things, Milord, I am not on the quantum, Milord. The quantum has not even been challenged. 1,87,000. There is no cross. Milord,
no
I
interest
say,
is also awarded.
Milord,
No interest is also awarded.
oh, no, Milord, 6%. Milord, that is 9%
no
in
interest,
default.
only default.
Yes, yes. Milord, that they are entitled to. Milord, I am not on these smaller things. Milord, I am on the principle when Supreme Court is time and again stating when the owner chooses and deliberately does not pay the insurance premium of his vehicle and that vehicle causes an accident, why shall insurance company who takes the precaution by informing the owner, listen, your policy is failed, informs the RTO, listen, this owner's insurance policy is failed, still insurance company be made liable to make payment? This is what Supreme Court has said, that no, insurance company should not make payment. It is the owner and that owner only, Milord, who will make payment to the claimants. These are my submissions.
Yes. Yes.
Great,
You want to submit today or do you want some time?
I will pass time, pray for time, because I will show that the earlier decision will prevail if the same bench, same two judges, not 3 judges bench, the earlier decision, that is constitution bench of 6 judges.
No, that was considered.
Yes, I will show.
No, if the said decision was considered and...
Yes, it has been. My Lord is doing that in Panaseti's case.
Yes.
Consortium confined to the, my Lord, the spouse. My Lord is saying subsequent judgment have considered. My Lord is giving to the parents.
Yes. If subsequent judgments are considered...
He is taking advantage of that every day.
Oh, one thing you are saying. You are saying at least 1 hour, but I have to
anyway,
say.
Yes, record an order.
What will you say now?
You say whatever you have to say.
Learned advocate for the appellant is present. Learned advocate for the parties are present. Learned advocate for the appellant concludes his submission. As learned advocate for the respondent claimant prays for time to submit. When can you come ready?
Within 3-4 days.
Let this matter appear on 19/8/2026 on at কটার সময়? At 2 p.m.
19/8.
Yes.
Yes.
Yes, my lord. My lord, on order dated 6/10/2026,
16th order, which matter? দিন একটু দেখি রেকর্ড।
order dated 6/10/2026, Learned Court was directed to file the additional paper book and written notes of argument. We are ready for that and file the same today.
Mr. Pahadi, you want to submit?
I will serve the copy. upon- I have already submitted.
Serve the copy.
Oh, you'll serve the
Ah.
copy?
I also,
Thereafter, let him come ready. Oh, you have received the copy?
Today I
the
You want to file written notes?
matter was already heard. Matter was already heard.
Only the written notes.
Only written notes of argument.
supplementary paper book
Additional paper book.
served today.
Now question is, so far hearing is concerned, hearing is concluded.
Concluded.
Only thing is you have filed your written notes of
Written
arguments.
notes of argument.
So let your learned friend file his written notes. Yes, record an order. Learned advocates for the parties are present. The hearing of this matter was concluded earlier. The supplementary paper books filed be kept with the record. As the learned advocate for the appellant has filed written notes of arguments, liberty is granted to learned advocate for the respondent insurance company to file written notes of arguments. The said written notes of arguments be filed on 20th August 20.
Yes.
20th August 2000. Let this matter appear on 20th August 2020 to 26 at 1 p.m.
With your honor seat.
Yes.
So Rajesh Singh is appearing, well.
8 and 9.
8 and 9, well.
No, this is item 7.
8 and 9, well.
7 হয়ে গেছে কি?
7.
না এটা তো 6টা হলো। হ্যাঁ, ও 7 হয়ে গেল। 8 and 9, 12:30 p.m. fix.
Yes, ma'am.
Anyway, he's not here. Let me wait. When he comes, I'll sit again. I wait করছি এখানে লঞ্চে, ঠিক আছে? আসলে
Milord, item number 8 and 9, Milord, for the appellant. My learned friend, Milord, has come up, Milord, with a cross objection as well. Your Lordship, Milord, this is mainly on quantum. Milord,
So go to Lok Adalat.
Milord, Lok Adalat would take a little time because, Milord, the point of law which I had taken, Milord, that the insurance money, Milord, as far as the claimant is concerned, Milord, they have taken money from the Workmen Compensation Court. And then, Milord, I had taken one point that in addition to that, Milord, they cannot come before the Motor Vehicles Court. Of course, Milord, that point is well settled now by Supreme Court. That is one point. And secondly, Milord, on the basis of 1 month's pay slip, this assessment has been made. Milord, the principal compensation, what has been assessed is, Milord, 60 lakhs. Milord, I have deposited nearly 1 crore before your Lordship's court. Milord, what I am requesting them, that on the basis of 1 month's salary slip, Milord, this assessment has been made. Either you give me the form 16 or give me 12 months salary slip, Milord, so that, Milord, this compensation, Milord, at least my client is satisfied and is not unhappy. Because, Milord, 1 month salary slip, which was taken into consideration, shows, Milord, more than 40,000 or 45,000 salary. And just preceding month, Milord, it showed a salary of 20 or 25,000. I am telling it to them, Milord, before this honorable court as well, I am requesting them, there is a vast difference. You show me the, Milord, form 16 or the 12 month salary slip, whatever is there, take that. I will not oppose this, Milord. So it may take, Milord, 5 or 10 minutes, or it may take, Milord, 1 hour. I do not know, provided, Milord, how they can help me. How they can help.
Some other day.
Yes, Milord, your Lordship will kindly fix it up some other day. I hope in between, Milord, they will help me out, Milord, to come to a final, Milord, assessment.
Yes.
Half an hour যদি ওরা সাহায্য করে দেয় তাহলে হয়ে যাবে।
Agore. Learned advocates for the parties are present.
এই তো
কি
তুমি আমার পলিটিক্স খেলছো
Hard learned advocates are granted time to obtain necessary instructions
Lordship.
in this matter. Let this matter appear on 11/9/2026 at 10:30 a.m.
Obliged to your Lordship. Extremely grateful. Milord, this is akin to, Milord, yesterday's matter, wherein, Milord, my Lord had passed an order disposed of. Milord, same
That's
accident.
the same.
Same accident, same facts, Milord.
Multiplier should be different.
Only multiplier, Milord.
Since,
And
my lord, 26 years.
You have you have
I have given the calculation sheet, Milord. It is the, my Lord's, Milord, file. Otherwise, Milord, all other facts remain same.
previous order. Yes. Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 4/12/2025 passed by learned Judge Bench 5 City Civil Court Calcutta in MSC case number 251 of 2021. Stop. The case of the appellant claimants before the learned trial court may be summed up thus. For paragraph. At the material place, date and time, the driver of the offending vehicle bearing registration number WB41 capital F stroke 3181 truck drove the same in a rash and negligent manner, endangering human life and safety to others. Stop. While the said vehicle reached near CCR bridge, the said offending vehicle violently collided with concrete mixture machine from its behind, which one was attached with the engine van and pulling and moving the same towards Ballyholt. Stop. As a result of the collision, the concrete mixture machine attached concrete mixture machine knocked the engine van, whereupon the claimant, along with his co-worker, namely Rabiul Ali and Shubodh Munda, occupying rear portion of the engine van, for seriously body injuries. Pursuant to filing of this case, notice was issued upon the opposite parties. The opposite party, vehicle owner, did not contest the case. Stop. However, the opposite party insurance company contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates for the parties, was pleased to dispose of the claim case by observing and directing as follows. In page 49, 41, folded page. The appellant insurance company, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. The respondent, being also aggrieved with regard to the quantum of compensation awarded, has filed a cross objection. Stop. Our learned advocate for the appellant insurance company and learned advocate for the respondent claimant peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the FIR was lodged after a period of 7 days. Thus, the case of the claimant is doubtful.
17 days.
17 days. Thus, the case of the claimant is doubtful. Stop. Learned advocate further submits that the vehicle number was not mentioned in the FIR and there is every chance of the vehicle being implanted. Stop. Learned advocate also submits that the compensation awarded by the learned trial judge is excessive. Stop. It is submitted that although the disability certificate mentioned 80%, but the learned trial judge considered the disability to be 100%. Stop. Learned advocate appearing for the claimant respondent submits that the learned trial judge did not commit any error in coming to the findings of the involvement of the offending vehicle. Stop. It is further submitted that the compensation awarded should be enhanced. Next, with regard to the first submission of the learned advocate for the appellant regarding delay in lodging FIR, it is held in different judicial decisions that in Indian society, family members of injured rushes to hospital and not to police station. Stop. In the instant case, I think in this case, the claimant lost the FIR.
No, Milord.
No.
Another injured person.
Another injured. Milord, there were 3 injured. The third injured lost the FIR.
Who is not any of the claimant.
Who is not any
in
of
the
the claimant.
instant case, as the complaint is lodged by one of the injured person and not by any other family members of
Milord,
the
FIR was single. Entire
yes,
charge sheet was single.
that has to
the
be.
Same FIR.
The claim case was different.
Claim case was different. Common FIR, common charge.
In the instant case, as the complaint is lodged by one of the injured person and not by any other family members of the claimant, the delay in filing the FIR cannot be treated to be fatal. Stop. Now, with regard to the submission of learned advocate regarding implantation of the vehicle, it is well known that a complaint may be lodged with regard to motor vehicle accident cases by mentioning the vehicle number and also against unknown vehicle. Stop. When a complaint is lodged against unknown vehicle, it is incumbent upon the police authority to cause necessary investigation and identify and trace out the said vehicle and thereafter proceed in accordance with law. Stop. In case the vehicle number is mentioned in the FIR, it is incumbent upon the police authority to consider as to whether the allegations made in the FIR are true and correct and thereafter proceed in accordance with law. Stop. In the instant case, the police authority, by applying their investigation machinery, traced out the vehicle and submitted the charge sheet. Thus, the said investigation report cannot be said to be perfunctory. Moreover, the investigating officer was examined by the insurance company, but nothing has come out against the vehicle owner with regard to collusion. Further, the vehicle owner in the instant case has filed written statement admitting the accident, and the said vehicle owner is also not examined by the insurance companies. Stop. Upon perusal of the evidence of PW2 and upon considering the documents filed, it appears that the learned trial judge has assigned reasons in coming to the findings of rash and negligent driving by vehicle number WB41F3181. Stop. Thus, the findings of the learned trial judge cannot be interfered with. Stop. However, with regard to the quantum of compensation, this court is of the view that considering the disablement certificate as it is mentioned 80% disability, and considering the nature of disability, it would be reasonable to proceed with the principle of 80% disability. In the event the monthly income of the victim is considered as rupees 5,000, 40% future prospect being added, the total monthly income comes to rupees 7,000. The annual loss of income earning capacity, the annual loss of income earning capacity comes to rupees 84,000. By applying the multiplier of 17, the total loss of income earning capacity comes to rupees 14,28,000. As the disability is 80%, the loss of income earning capacity comes to rupees 11,42,400. Stop. Considering the medical expenses of rupees 2,20,500, general damages rupees 1 lakh, attendance charges rupees 6 lakh, future medical expenses rupees 1 lakh, loss of marital prospect rupees 2 lakh, the total compensation by arithmetical calculation comes to rupees 23,62,900. Stop. However, this court is of the view that compensation of rupees 23,50,000 is just and reasonable. Hence, this appeal FMA 411 of 2026 along with COT 53 of 2026 stands disposed. The judgment and award dated 4/12/2025 passed by learned Judge Bench 5, City Civil Court, Calcutta, in MSC case number 251 of 2021 stands modified to the extent that the claimant respondent number 1 is entitled to rupees 23,50,000 from the appellant Shriram General Insurance Company Limited. Stop. The appellant Shriram General Insurance Company Limited shall deposit rupees 23,50,000 along with interest at the rate of 6% per annum from the date of filing claim case till today. How much was awarded by trial court?
26,48,500.
26
lakhs 48,500.
In the event, acha ki likhlam bolo to last line ta. The appellant insurance company shall deposit rupees 23,50,000 before the Registrar General High Court, Calcutta, along with the interest at the rate of 6% per annum. Stop. Such deposit shall be made within 8 weeks from the date of communication of this order. Stop. In the event compensation awarded by the learned trial court is already deposited, no further deposit be made. The appellant insurance, the respondent claimant will be entitled to withdraw.
Kindly insert the name, my lord, Mumtaj Biswas, because there is some alias is there, 40 on page 40.
The respondent Mumtaj Ali.
Mumtaj Biswas.
Mumtaj Ali alias Mumtaj Bishas,
My lord,
alias Mumtaj Ali Bishas, alias Mumtaj Ali, all, everything.
my lord, kindly see the
Everybody is
ordering-
entitled.
My lord, kindly see the ordering portion, page 41. Page 41. এই নামে চেক না হলে তো এ করা যাবে ইন কেস অফ
Okay, let us see what the trial court has said.
yes my lord এটা লিখে দাও Mumtaj
Where it is said, name is not mentioned.
name
Okay,
not-
Mumtaj Bishas.
yes Mumtaj
The appellant,
Page
Mumtaj
41.
Bishas, he is entitled to withdraw the compensation upon compliance of necessary formalities. The balance amount, if any, along with accrued interest, be returned to the appellant insurance company.
otherwise my lord the check will not be encashed.
No, if all names are mentioned, no difficulty. Whatever you have mentioned in the cost title, then there is no difficulty.
One in
Any mentioning?
yes, with
My lord,
number
my
one.
lord,
With regard to item number
my lord.
104 and 5, which was appearing
Just a minute. এটা তো দিয়ে দিচ্ছি আর দুই আর
with regard to item number 104 and 5.
Yes.
This appeal was disposed of
104
by
and
this honorable court. But one application is still pending for disposal. That is the,
come under the heading application.
yes, my lord, let it appear.
104 and 5 application heading এ দিয়ে দেবেন।
My lord, item number 97 for extension of interim order, my lord.
Item?
I've served the notice to the other side. 97, my lord. 92, sorry, my lord, 92.
Yes, 97 record and order.
92, my lord. I stand corrected. 92. 92, my lord.
Yes, record and order 92. Learned advocate for the appellant is present. Learned advocate for the parties are present. As this matters cannot be taken up today, the matter stands adjourned till 19/2026. The interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Item 45 for extension of interim order.
Item
45.
45, Your Lordship, I am appearing for the Union of India.
just a minute. Item 45.
Yes, your lordship.
Yes, Your Lordship, 45.
45, Mr. Nag is appearing on behalf of respondent IIT.
Okay, just a minute. Yes, record and order. Item 45.
Lordship,
Just a minute. Just a minute. I am adjourning it. I am extending the interim order for a limited period.
I have been instructed is the petitioner is enjoying interim.
Yes, but the
Constantly being.
no. Matter has to be taken up. Learned advocates for the parties are present. As this matter cannot be taken up today, the matter stands adjourned till দেখুন তো
Lordship, kindly fixed a date with time, your lordship, because he's not getting salary since 1 year, your lordship.
Sixteen 9/2026 at 2 p.m. The interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Grateful, lordship.
Yes, any other mentioning?
My lord, with regard to item number 186.
Yes.
My lord, Mr. Singh's, my lord, appeal.
Yes.
The point involved is that non-deduction of income tax.
Yes.
My lord, I am agreeable. Let it appear as to be
Go to
mentioned.
Lok Adalat and
No,
settle.
no. My lord.
If you want to get it hard, just wait for some time. Either you go and settle the matter or you wait.
My lord, let it appear as to be mentioned on tomorrow.
No question of to be mentioned now. Either you have to go and settle the matter or you just wait for the time being.
My lord, item number 75.
75.
First time stay. In the morning I mentioned, my lord.
Yes, item 75. Yes, item 75, record and order. Learned advocate for the appellant is present as this matter.
My
could not
lord, I'm
be-
praying for stay in this matter, my lord.
I'm just granting you some limited protection. The matter.
My lord
cannot
will,
be-
it will take 2 minutes. My lord will grant me this.
No, actually, you see, there is an indication in the list. In this way, it will, if both sides will,
This is coming up for the first time. Stay.
very well, you see, there is one indication in the list. There should not be debate.
But I'll wait then, my lord.
Learned advocate for the appellant is present. As this matter could not be taken up today, the matter stands adjourned till 19/8/2026. As this matter is sub judice before this courts, the appellant is granted opportunity to seek adjournment before the learned trial court, which may be considered. I'll take it up on 19th. Item 1.
I'm for the appellant, my lord.
I'm for the claimant respondents.
Hence, this appeal FMA 874 of 2025, along with COT number 122 of 2025, stands disposed. The judgment and award dated 4th March 2025, passed by learned judge, Special Court Electricity Act, Additional District Judge Asansol, Paschim Bardhaman in MSC case number 1 of 2014, stands modified to the extent that respondent claimants are entitled to rupees 25 lakh from the appellant Indasin General Insurance Company Limited. The appellant Indasin General Insurance Company Limited shall deposit rupees 25 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is deposited, the balance amount be deposited. The claimants will be entitled to withdraw the compensation upon compliance of necessary formalities. Deficit court fees on enhanced compensation be paid within 4 weeks before learned trial court. Trial court records be returned by special messenger cost to be deposited by claimants within 1 week.
My lord, if there is any balance amount, it may be refunded to the appellant.
The compensation is enhanced. There will not be a balance amount.
I'm grateful, my lord.
Yes. अच्छा एक मिनट ये तो देखो तो कभी just wait. Yes, record an order. Record an order. Today, learned advocates for the parties are present. Today was fixed for judgment. As the judgment could not be made ready, let this matter appear for judgment on 20th August 2026 at 2 p.m. Same order.
On 20th at 2 p.m.
Yes. 20th, it will be judgment. So 20th, the judgment will be delivered at 2 p.m. Your presence of junior is sufficient.
Out of
On 20th?
on 19.
Then let it, আচ্ছা জাগে এটা পরেরটাতে সেম অর্ডার করে দিন, ওটা 21 তারিখে করে দিন। 19 there are Otherwise,
for judgment.
otherwise it will cause some difficulty. Either 20 20 তারিখ দুটোর সময় থাক। হ্যাঁ দুটোই 20 তারিখে দুটোর সময়। হ্যাঁ দুটোই।
Kindly taken 77 application for stay, only stay.
77.
In the morning I mentioned.
Acha 77 recorded. Yes, you are appearing 77. Acha 77 recorded order.
Brilliant insurance company and I have deposited statutory amount.
A 77 recorded order. Learned advocate for the appellant is present. As this matter cannot be taken up today, the matter stands adjourned till 19/8/2026. As this matter is sub judice before this court, the appellant is granted opportunity to take necessary adjournment before the learned trial court, which may be considered. Yes, I shall keep it next.
My lord, I am taking stay, my lord.
I have granted you opportunity. You see, I have given some indication. It would not be proper to go against that indication.
Tomorrow
I'm keeping it on 19th. In the meantime, if there is any problem, you seek adjournment. That liberty I have granted you before the trial court. If execution case is fixed in the meantime, that liberty I have granted. Yes, which item?
82, my lord.
82 for?
My lord, there is a stay order. My lord had passed an order dated 1st July 2026 and granted stay for 6 weeks.
Yes.
The 6 weeks expires today, my lord. In the meantime, my lord had directed an indemnity bond to be furnished. We have done that.
Yes. Mrs. Paul, you are appearing in this matter.
No, I'm.
Oh, yes, Mr. Singh, you are appearing in this matter.
Mrs. Pal appeared, but Mr. Singh is. No. Last দিনে আপনার হয়ে উনি দাঁড়িয়েছেন।
No, last date, last occasion, probably you appeared. Okay. Yes, IT2, let it appear on the next day.
To be mentioned, let it appear whatever.
My lord, the stay order expires today, my lord.
Anyway, I shall keep it on 19th. In the meantime, yes, record an order. Learned advocates.
My lord, I have already complied with your lordship's
Learned
order.
advocates for the parties are present. As this matter could not be taken up today. Are you consenting to the extension?
Not now, my lordship,
Okay.
the extension till 19th.
Okay.
Since your lordship is fixing it upon
The
19th.
matter, let this learned advocates for the parties are present. As this matter could not be taken up today, the matter be fixed on 19/8/2026. The interim order passed earlier stands extended till 21/8/2026.
Okay.
Deeply obliged, my lord.
हम दादा से पूछे
हाँ।
कि हमको पैसा जमा करने को बोलते हैं तो आप क्यों नहीं करते? बोला नहीं हम ही करेंगे। बोले
Lordship
बोले I appear for the opposite party.
Lordship, before placing of the judgment of the both the court, I place the substantial question of law which was framed at the time of admission.
Yes.
Page 52, my paper book. Page 52, Lordship. Two substantial question of law was framed.
I don't need that.
First is Lordship.
You are the plaintiff appellant.
I am the defendant appellant. Both whether the civil court has jurisdiction to entertain suit concerning the violation of any provision of the West Bengal Panchayat Act 1973 and the West Bengal Panchayat Samiti Administrative Rule 2008, creating an implied bar to the jurisdiction to entertain and maintainable of the suit. Main first substantial question, maintainability of the suit. Second, Lordship, whether both the courts below were justified in passing a decree for demolition of a part or portion of the building which has been constructed illegally in violation of the aforesaid rule solely on the basis of the inspection report filed by the Advocate Commissioner, who does not have the expertise in relay and survey of the property without ascertaining the exact boundary line between the properties owned by the respective party. That is inspection report.
Panchayat authorities are party in this suit.
Lordship.
Panchayat authority.
Panchayat authority also party.
You are representing private respondent.
Plaintiff. They representing the plaintiff. I checked it also. ইয়েতে আছে মেমোতে থাকবে তো yes respondent number 2 yeah
The decree is executed.
Lordship.
Decree is executed or not executed?
No, stay order was
Stay is
passed
there, yes.
Lordship. Lordship was it was extended time to utilization that was still pending Lordship. In second question subsequent question of the inspection report under order 39 rule 7 Lordship knows inspection report only bringing the local features, not measurement. Then I Lordship place the judgment of the trial court. Lordship. It was start page number 1 Lordship. Page number 1 only lawyer, the name of the lawyer and number. Lordship. Next page Lordship. Page
Yes.
2 case of the plaintiff. Page 2 Lordship case of the plaintiff. Plaintiff case in brief is that the suit property described in the schedule core consists of two parts, lot 1 and lot 2, situated under Chakdaw PS, which is within the jurisdiction of this court. One Munindra Kumar Chattopadhyay was the original of the schedule core lot 1 property. He sold the property to one Amrita Kumari Biswas through a registered deed of sale being number such and such dated 7th November to 1956. Said Amrita Kumari Biswas sold the same to Nirod Baran Biswas by executed deed of gift being number such and such dated 21st April 1984. After death of said Nirod Baran Biswas, the property devolved upon his wife Snelata, his son that is the plaintiff, and his three daughters namely Jayanti, Mithu and Papu as his legal heirs. Said wife and three daughters of the deceased Nirod Baran Biswas transferred their share in the schedule called lot number 1 property to the plaintiff by executing a deed of gift being number such and such dated 13th June 1999. Plaintiff's mother Snelata, after purchasing the schedule called lot number 2 from one Manohar Biswas through one deed of sale being number such and such dated 5/5/1966, become the owner of the same. Plaintiff recorded his name in the record of right in respect to the suit property from the year 1956 and 1966 respectively, which is about 50 years. Light and air in the southern part of the suit property have been enjoyed continuously. The dependents who are the owner of the adjacent southern side plot of the plaintiff's property, violating the building rules, have constructed their house leaving space of 30 inches from the scheduled cost of the property and are trying to do further construction extending the cantilever of the said house leaving space of 8 inches from the plaintiff's property. If such construction is completed, plaintiff access to light and air in his property will be wholly interrupted and it will be nuisance. According to previous law, 3 feet gap was mandatory, but now as per present law, both sides should be leave 4 feet space each from the common boundary line. Before making construction in their land, in the northern side of the defendant house, there are 2 windows from where the entrance and the interior parts of the house of the plaintiff are visible, which will interfere with the sanctity of ladies in the plaintiff house. When the plaintiff went to the pro forma defendant number 1, which is the local panchayat, to communicate his objection towards proposal sanctioning of building plan of the defendant house, the pro forma defendant number 1 refused to take any objection. Plaintiff is certain that the defendant have no sanctioned building plan as local panchayat will not sanction any building plan which violate the building rules. The cause of action arose on 31st December 2014 and 18 January 2015 when the building was constructed by the defendant. Plaintiff raised for demolition the defendant's illegal construction and seek permanent injunction as to any further construction by the defendants. Regarding title of the property, no dispute. That was admitted. Defense case loss, defense version. Defendants are contesting a suit by filing their written statement. The defendant specifically denied that the plaintiff has recorded the suit property in his name They denied that they have constructed their house violating the building rules or constructed the same 3 inches away from the plaintiff's property. They also denied that they are trying to make cantilever on their house 8 inches away from the boundary of the plaintiff. They further denied that if the construction of the defendant's house is completed, that will create a nuisance or the access of the light and air of the plaintiff's property will be blocked. Defendant denied that from the 2 windows of the defendant house, the entrance and the room of the plaintiff house will be visible, or as a result, the sensitivity of the female member of the plaintiff family will be at stake. The defendant said that the defendant number 1 got 4.334 decimal of the land in the suit plot by way of inheritance and recorded her name in the record of right. She applied for sanctioning of the building plan. Lordship, kindly take note of it, which was sanctioned by Mandarpur Gram Panchayat. She transferred 2.167 decimal to the defendant number 2 by registered deed of gift being number such and such, and the rest 2.167 decimal to the defendant number 3 by another registered deed of gift being number such and such. Defendant number 2 and 3 constructed the house as per the building plan sanctioned in the name of the defendant number 1, leaving 3 feet space from the boundary of the suit property, and they are making cantilever of their house as per building rule. The house of the defendant is situated at the southern side of the plaintiff's property. Defendant alleged that the plaintiff violated the building rule, constructed his main building and boundary wall without leaving any space from the common boundary line of their property. The defendant number 1 says that she has no interest over the property of the defendant number 2 and 3. The defendant denied that any cause of action arose on 31st December 2014. They seek dismissal of the suit with cost. Then issue. Following issues were framed by the court on the basis of the pleading and documents filed by the parties. First issue, Lordship, is the suit maintainable in the present form and prayers. Specific issue was framed. As the plaintiff any cause of action to file this suit, whether the construction made by the defendant by violation of municipal rules and whether construction line and air of the plaintiff's land. Lordship, kindly take note of the issue number 3. As per Panchayat Act, Panchayat authority is the only authority to see to that extent. 4, Lordship, is the plaintiff entitled to get any decree as paid for? 5, Lordship, to what other reliefs is plaintiff entitled under the law and equity. But this court considered that issue 3 is required to be reframed and additional issue are required to be framed. Hence, the issue are recast as follows. Is the suit maintainable in its present form and prayer? Has the plaintiff any cause of action to file this suit? Whether the construction made by the defendant is in violation of municipality rule? Whether the construction made by the defendant is obstructing the light and air in the plaintiff's property? Whether the windows of the defendant's building interfere with the privacy of the plaintiff house? Is the plaintiff entitled to get any decree as prayed for? To what other reliefs is the plaintiff entitled under the law and equity? Document exhibited, Lordship. Exhibit of the plaintiff, exhibit deed of gift being number such and such. Exhibit 2, deed of gift.
Plan was exhibited. Building plan.
I come to that. Yes. Lordship, exhibit G, page number 7, last portion.
Sanction plan.
Sanction plan by the Mandarpur Gram Panchayat. Lordship.
Yes.
And above Panchayat money receipt for sanctioning plan. Tax is also and deed also is decision with regions. Now the issue are being taken for the discussion in the following manner. Issue number 1, most vital loss, because substantial question of frame regarding maintainability of the suit. During argument, learned advocate for the defendant challenged the maintainability of the suit on the ground that the defendants have constructed their house as per sanction plan of the local panchayat. Denying the plaintiff's claim, he submitted that it is the local panchayat who looks after whether or not any building is constructed as per building rule. He furthermore drew the attention of the court toward the boundary mentioned in the plaint where the defendant house is not mentioned. I showing the provision or Lordship knows section 23. If any violation, Panchayat authority is the authority, only authority to take steps.
Violation of the sanction plan.
Yes. If any violation, Panchayat authority section 23 5, Lordship last, authority is the only authority to see whether any violation or not, but civil court had noticed. This court finds that from the paragraph number 10 of the epidemic in chief, DW1, it is evident that defendants have admitted that their house is situated at the southern side of the plaintiff's property, and therefore non-mention of the defendant house in the boundary part in the plain does not render me should not maintainable. I placed the plaint. In the plaint, my schedule was not there. In the plaint, I showing the plaint. In the plaint, praying for demolition my house, but my schedule was not mentioned in the plaint.
But in the body of the plaint, it was there.
No.
Oh,
only saying defendants constructed house.
No,
When- in
defendant
which land?
suit property.
Suit property, the plaintiff's property, given the plaintiff's property. But
Okay.
he paying,
Defendants, the property on which the illegal construction is
that
built
was not given in the plaint.
that was not reflected.
Not reflected in the plaint. I showing the plaint lawsuit subsequently. This court finds that from the paragraph 10 of the epidemic chief, DW1, it is evident that the defendant have admitted that their house is situated at the northern side of the plaintiff's property, and therefore non-mention of the defendant's house in the boundary part in the plain does not render me should not maintainable. Furthermore, this court considered that since this suit relates to the declaration of title and right to have access the light and air in the suit property and to secure privacy of the interior parts of the plaintiff property, this court has jurisdiction to decide upon the matter. Also, I place the prayer, not just like it. Learned issue number 2. Learned advocate for the defendant submitted that defendant's property is situated far away from the plaintiff's property, and he left sufficient place from the boundary of the two plots, and therefore the question obstruction of light and air cannot and does not arise. The cantilever, which is situated at the top of the ground floor of the plaintiff's building, is at much higher level from the ground. Therefore, question of obstruction cannot and does not arise at all. After perusing of the exhibit 7, it appears that the defendant's property is situated at the northern side of the plaintiff's property. The distance of the defendant house from the boundary of the property of the plaintiff is 2 feet 10 inches. House from the boundary of the property, plaintiff is 2 feet 10 inches. Furthermore, as per the report of the Learned Commissioner, let's kindly take up note. As per Commissioner under Order 39 Rule 7, plus I placing this Order 39 Rule 7 lawsuit knows Commissioner power only bringing the local feature, cannot be
Order
given
26, Rule 9.
That is yes.
And
I place this judgment for the difference between the Order 26 Rule 9 and Order 39 Rule 7. What is far difference? Order 39 Rule 7, Commissioner only went there and took the local features, nothing more. Have no power. Furthermore, as per the report of the Learned Commissioner, the defendants are constructing a new pillar extending the cantilever. The distance between, lawsuit kindly take it, note it. Distance between the cantilever and the plaintiff's property boundary line is 11.5 inches. Therefore, this court finds that there is sufficient cause of action of this file this suit. Issue number 3, 4, 5, 6, and 7. All these issues are closely interconnected. They are discussed together for the sake of convenience and brevity and to curb up the unnecessary repetition. During the argument, Learned advocate for the defendant submitted that defendant had left sufficient space while constructing their building as per the commissioner report. There is a, again lawsuit, commissioner report, there is a sub room and vacant land and the adjacent south of the plaintiff house in the eastern side of the two plots, there is a Pakka road. In cross-examination of the PW3, she stated that defendant's entire property is sub-room and in front of that there is a passage which is vacant. She also stated that the construction is done in the ground floor and the cantilever is on the top of the first floor. Learned counsel for the defendants drew the attention of this court towards the answer of point number 1 in the commissioner report, whether Learned Commissioner has stated that the distance between the boundary of the two property is 2 feet 8.5 inches, and subsequently stated that the defendant have constructed their house in the southern side of the plaintiff's property, keeping distance of 2 feet 10 inches. He further stated that if the plaintiff has made any complaint before the local panchayat, he could have produced the document to show the same. Complaint, nothing showing any complaint, that was not exhibited. The learned advocate for the defendant stated that at the time of commissioner, the defendants were not present there, and the commissioner acted as per the instruction of the plaintiff PW2, who gave evidence in favor of the plaintiff as a neighbor. He is the sister-in-law of the plaintiff, so he gave evidence in his favor from other interested. Learned counsel for the defendant did not prove any citation in favor of his case. Learned counsel for the plaintiff submitted that there is no dispute regarding the title of the properties. He stated that as per the West Bengal Panchayat Samiti Administrative Rule 2008, both sides should have lived at least 4 feet space from the boundary. He also pointed out that the learned commissioner has stated in her report that the defendant have constructed their house leaving two pace of 10 feet 10 inches, which is lesser than the 3 feet. She also stated that as the height of the defendant building is not very high, it is possible to take measurement of the cantilever from the font standing on the earth. He stated that when the learned commissioner submitted her report in the court, defendant raised no objection, and the defendant number 2 in his evidence admitted that his advocate has consulted him regarding the matter of commission. He pointed towards Rule 72 of the West Bengal Panchayat Rule 2008, which stipulated that at least 90 centimeter space must be left from the each side of the plot while making a new construction. He cited the 3 judgment in favor of his case, which is referred in. Placing this judgment later on lawsuit. Peruse all materials on record. This court finds that it is an admitted fact that the defendant have constructed their building at the southern side of the plaintiff's property. It also appears from the commissioner report that the defendants have constructed the building keeping in distance which is less than 180 centimeters from the side of the plaintiff building, which is pre-existing one, and that of the defendants. It is also clear from the commissioner report that the defendant have constructed a pillar extending the cantilever for the purpose of doing further construction over the existing structure. In AIR 1996, Gujarat 60, the Honorable Gujarat High Court observed that no construction can be raised without building plan, and construction cannot be made contrary to law. In AIR 1985, Delhi 293, the Honorable Delhi High Court observed that the plaintiff has right to seek the aid of the court in the restraining his neighbor from raising any construction which is contrary to any bylaw or from raising any unauthorized construction. This court finds that the exhibit number F, one of the direction to construct the building is to leave the pace of 90 centimeters from each side of the plot. By signing of the document exhibit F, the defendant number 1, in whose name sanction building plan had been issued, agreed to be bound by those direction DW1 in his cross-examination, and said that from the cantilever of his house till the house of the plaintiff there is distance of 2 feet to 2.5 feet. He denied that the interior parts of the plaintiff house are visible from his property. It is found from the cross-examination of the DW2 and from the commissioner report that there is a window at the north of the defendant house which faced towards the plaintiff property. PW1, that is the plaintiff, has stated that a building on the suit plot was constructed in the year of 1956. At the time of cross-examination, PW3 has stated that at the time of local inspection, construction work was going on. Her report, Learned Commission stated that from the window of the defendant house, all incidents inside the plaintiff house were getting visible. That was not a commissioner part. Commissioner cannot say to that extent. After perusing of the both oral evidence and documentary evidence adduced by both the parties, particularly exhibit number 1, this court is of the view that there is no dispute between the parties regarding the title of each other in respect of the property. Hence, the plaintiff is entitled to decree of declaration of his title. Now, Rule 72 of the West Bengal Panchayat Samiti Administrative Rule 2008 clearly states that any structure or a building within the jurisdiction of Panchayat Samiti shall be erected or constructed with a setback of at least 90 centimeters from the each side of the plot. In doing so, there shall be a minimum perpendicular distance of 1 meter and 80 centimeters from the side of any proposed new building to the side of the existing building. The instruction, the direction laid down in Exhibit F undoubtedly show that there is a duty cast upon the applicant to construct the building as per those instructions. As per instruction number 2 and 3, at the second page of Exhibit F, the applicant must construct the boundary wall leaving pace of 90 centimeters from the foresight of the plot on which construction is proposed to be made, and there must be a distance of 1.80 meter between the two buildings. It is evident from the Exhibit F that the Mandarpur Village Panchayat granted the permission for construction of the building in the name of Dependent 1, and Dependent 1 gave undertaking to comply those instructions stated therein. In their written statement, the dependents have stated that they left 3 feet space from the boundary of the plaintiff, but from the report of commissioner, it appears, kindly take note of it. But from the report of the law commissioner, it appears that the dependent have constructed their building leaving space 2 feet 10 inches. That is 86.36 centimeter. Kindly take note of it. Therefore, by not following the instruction of the local panchayat, the defendants certainly have constructed their one-story building violating the building rule. PW3 in her cross-examination has stated that at the time of local inspection, she saw that the construction was going on in the defendant's property. DW1 during his cross-examination admitted that he has extended the cantilever for construction and said from the cantilever till the house of the plaintiff, there is a distance of 2 feet to 2.5 feet. From the exhibit number 7, it appears that the defendant have constructed new pillar, extend the cantilever, and from the cantilever to the boundary of the plaintiff's property. There is a distance of 11.5 inches. In the local commissioner report, London commissioner stated that the inner part of the plaintiff house were visible from the window at the north side of the defendant's property from her evidence and her report. It appears that the defendants were not present at the time of local inspection. Nowhere in her report or in her evidence it is appeared that she entered into the defendant's property. Lordship, kindly take note of it. Nowhere in her report, in her evidence, it appeared that the commissioner report and that she entered into the defendant's property. Without entering the defendant's property, they taking measurement. They seen that the window is visible from the plaintiff house, everything. There is a window in the northern side of the defendant house, and air of the plaintiff house are visible from there. This code has gone through the exhibit number 7 and evidence adduced by PWs. Very careful, and this code is of view that there is a certain ambiguity in the evidence. Lordship, kindly take note of it. This code in view that there is a certain ambiguity in the evidence adduced by the PW3, that is the commissioner. It is not clear that how can a one-story building have cantilever at the top of the first floor, and if it is on the top of the first floor, then how can it be not very high or high? How can it come within the reach of the commissioner from the ground floor? It is an admitted position that commissioner was held ex parte. As such, it can be assumed that the commissioner did not enter the defendant's property. Therefore, this code is not willing to attach much importance to her statement in point number 3 regarding visibility from the defendant window. Therefore, the point relating to exact distance of the cantilever from the plaintiff house and interfere with the privacy of the plaintiff's family member due to that of the defendant window on the northern well remains unclear. Since no further evidence corroborated has been given by the plaintiff, this court considered these 2 points to be not proved. Therefore, this court considered that only the point number 1 of the exhibit 7 is acceptable as undisputed. It is clear that the defendants have not complied the direction of the local panchayat and constructed their building violating the mandates of West Bengal Panchayat rules regarding construction of a new building. It is well known fact that the statutory rules for living setback mandatorily have been framed, keeping in view various concerns like general convenience and resident of the locality of a locality, sanitation and ventilation in house, avoiding or preventing the chance of the spreading of fire from the one building to another in times of emergency. Emphasized upon these concerns, the Honorable High Court of Calcutta 1965, AIR 1965, Calcutta 148, 1968, A68, CWN 757, observed that it is indisputable that infection of the light and air of any other kind of actionable nuisance will give rise to a light action against the infringed landowner or owner of the building. Therefore, this court is of the view that the plaintiff has been successfully established his case in part. The plaintiff is entitled to a decree declaration of title in respect to the property described in lot number 1 and 2, schedule co in the plaint. The plaintiff also succeed to establish that the dependence building has been constructed in violation of law of the land for the time being. However, the plaintiff has failed to prove that the distance of the cantilever of the building is at the distance mere 8 inches in as much as the plaintiff has failed to prove that the window on the north wall of the dependent house causes interference with the privacy of the family member of the plaintiff. The plaintiff has also not been able to prove it all the light and air in the premises be obstructed or not. Everything plaintiff failed proof, hence that the suit be the same decree in part on contest, the defendants are hereby permanently restrained from making any construction in violation of the rule laid down in the West Bengal Panchayat Samiti Administrative Rule 2008. Together with direction of the Panchayat, the defendants are further directed to demolish such part or portion their building which has been constructed illegally in violation of the rule stated herein above. The defendants are to comply the order within 2 months from the date of the judgment. But regarding violation, portion of violation, nothing was there.
Yes, let us appellate court's judgment.
Yes, Lordship. Appellate court judgment, Lordship. Page 23, Lordship. Start. Page 24.
Yes.
Factual aspect, Lordship. They cannot place again, Lordship. Repetition, Lordship. Page 25, Lordship. Para. Para 5, Lordship. Page 26, para 5. Then Lordship, page 27, decision portion. I will placing only decision portion. Factual aspect, Lordship, is the same, Lordship. Decision with regions, Lordship, before that points for determination. Whether learned trial court erred in appreciating the law and facts of the case, whether there is any ground to interfere with the finding of the learned trial court. In this argument, learned advocate for the appellant submitted that the court has passed the decree which is not executable. There is no schedule of the property in the plain. Lordship, kindly take note of it. There is no schedule of the property in the plain which has to be demolished.
Which page you are reading? 26.
27, Lordship. Decision portion.
27, yes.
Because factual aspect is same.
Yes.
I repeated the decision portion, Lordship. In this argument, learned advocate for the appellant, that is my client, submitted that the court has passed the decree which is not executable. There is no scheduled property in the plain. Lordship, kindly take note of it. Which has to be demolished. There was no violation of the building rule. Defendant have constructed their house according to the sanction plan. There is no definite proof before the court that the construction has been made ignoring the existing rule. Commission work was held in the absence of the defendant and it is not trustworthy. Issue number 4 and 5 have been decided against the plaintiff, but he has not prepared any cross appeal. Point number 2 and 3 of the commissioner report was not accepted by the learned trial judge. The suit has been decreed relying on the point number 1, Commissioner report and municipal rules, but the suit property is situated with the Panchayat area. The Easement Act is not applicable in the West Bengal. Mere violation of the bidding rule or plain without infringement of some right is not actionable in law. There is no dispute regarding title, no There is no dispute regarding title nor contractual obligation between the parties. The commissioner has power to relax violation unrelaxable municipal rule. The decree passed by the court below is illegal and it is liable to be set aside. In support of his argument, he cited some decision. I placing those decision later on lordship. Next page, lordship. On the other hand, learned advocate for the respondent submitted that description of the property on which defendants have constructed their house is known to them. Plaintiff is not supposed to know the details of their properties. They have not denied that they are not the owners of the property on which the construction has been made violating the Panchayat rule. The principle of municipal act is also applicable in the Panchayat area. No objection was filed against the commissioner report. It has been accepted by the court and it is binding upon the defendant. It is the choice of the plaintiff whether he could file cross appeal or not. The principle of Easement Act is applicable in West Bengal. The plaintiff has proved that defendants have made construction without leaving required vacant space. The decree passed by the learned court below is very much executable as per law. There is no merit in this appeal and it is liable to be dismissed. In support of his contention, he relied on the following decision. Next page, lordship, paragraph 9. Neither parties have denied or disputed their respective title in the subject matter of the suit. There is no ambiguity in the finding of the learned court below that the plaintiff has title in the cause scheduled property. Plaintiff also admitted the title of the defendant in the land on which dispute portion building has been constructed. Moreover, they have produced their title deeds. Plaintiff has not challenged the finding of the learned court below on any issues. Suit has partly been decreed in favor of the plaintiff, holding that the defendant have constructed their house violating the Rule 72 of the West Bengal Panchayat Samiti Administrative Rule 2008. This is the only disputed point which is to be decided in this appeal. The point raised by the learned advocate for the appellant that the plaintiff has no right to file the suit as there was no dispute of title and he failed to prove any special damages is not sound one. It is the allegation of the plaintiff that the defendants have constructed their house beside the existing house of the plaintiff without leaving sufficient vacant space as required under the law. No contractual obligation is necessary to maintain a suit of this nature. The law imposes an obligation upon its subject to follow. There was legal obligation upon the defendant to construct their house in accordance with law. The plan was sanctioned by the competent authority to construct the house following the existing rule. On scrutiny of the evidence, it was found that by the trial court that the construction made by the defendant was in violation of the rules. It was the duty of the competent authority to compel the defendant to raise construction as per rule. Plaintiff has alleged that he tried to submit his complaint before the Panchayat, but it was not entertained. That is why he was compelled to take the course of law. Even if the Panchayat has power under the law to relax the construction rule, it should be exercised in a judicious manner and it has to be based on sound principle. If the Panchayat has to approve the authorized deviation of plan in constructing a house, it has to be based on the sound discussion. It cannot be arbitrary or whimsical. Civil code has every jurisdiction to enter a suit of civil nature. But this dispute is not a civil nature, unless it is especially barred by law. The view that until and unless the plaintiff can prove any special damage, a suit of this nature is not maintainable, is not correct. It is a duty of the court to enforce the law when there is a violation of law by the authority entrusted with the duty to execute the law. In the instance case, it was the duty of the Panchayat to compel the defendant to make their construction leaving the vacant space of 4 feet from the common boundary of the plaintiff. It has been alleged by the plaintiff that he tried to bring this within the notice of the Panchayat, but the authority remained silent. No complaint was exhibited, nothing. Remained silent and did not take cognizance of the matter. Even if it is presumed that the plaintiff did not file any complaint before the Panchayat for enforcement of the rule, it will not debar the plaintiff to seek remedy in civil suit. Failing of the complaint before the Panchayat is not a condition precedent to institute a civil suit when there is a violation of statutory obligation. The dependents were bound by law to construct their house following the construction rule applicable in the Panchayat. Learned commissioner who inspected the disputed property submitted report before the court that dependents have reached the construction in clear violation of the rule. They have reached the construction leaving less than required vacant space. The report of the commissioner has been accepted by the learned court, and there was no objection against the report. Therefore, there is no ground to disbelieve the report of the learned commissioner. Lordship knows the local inspection report to extend what evidentiary value. Learned commissioner has in her report clearly mentioned that the defendant have constructed their house leaving only 2 feet 10 inches. Only 2 feet 10 inches vacant space from the common boundary, which is less than the prescribed norms. Prescribed norms is 90 centimeter, means lordship near about 3 feet, not 4 feet. No evidence has been produced by the defendant that the deviation has been approved by the Panchayat and rule was relaxed. It is apparent from the plaint that the schedule of the defendant's property, lordship kindly take note of it, that is the observation. It is apparent from the plaint of the schedule of the defendant's property has not been mentioned without mentioning of the defendant property, decree in that property. In my view, this is not a fatal to the plain case. It appears from the paragraph 14, kho and go of the plain that description of the defendant's property has been given, and it is sufficient to identify the property. Moreover, the plains exhibit G and G1 have been produced before the court, which are sufficient to identify the disputed construction. Therefore, I am unable to accept that the view that the decree is inexecutable. There would be no doubt to identify the disputed construction. It is settled proposition law that the Easement Act is not applicable in the state of West Bengal, but its principles are very much applicable. Therefore, the contention of the learned advocate for the appellant cannot be accepted. Moreover, plaintiff has not prepared any cross appeal on the point of easement right claimed by him, which was refused by the learned trial court. There is nothing on record to prove that there was no violation of the construction rule. When it is proved that there was a violation of the rule, it is immaterial to measure the extent. Lordship, kindly take note of it. It is immaterial to measure the extent of deviation of the plan. Without extension, how demolition? Everyone was bound to follow the legal obligation. None of the decisions cited by the learned advocate for the appellant can rescue them. They are no help to them. For this reason, I do not agree with the view of that mere violation of the building rule without proof the infringement of some right is not actionable. No other points was raised by either parties. There is also no dispute regarding the title in the suit property. Both parties have admitted the title of each other. However, plaintiff has produced documentary evidence in support of each title, which have been discussed and accepted by the learned court below. Therefore, no finding is required to be recorded on any other point in view of the foregone discussion, and the reasons of this court is of the view that there is no ground to interfere with the finding of the learned trial court. No illegality has been committed to decide the suit. All the findings of the learned court are hereby affirmed. As a result, appeal succeed.
Appeal fails.
Appeal
Actually,
failed.
your appeal fails.
Yes.
Actually, appeal fails.
It was wrongly typed. Appeal was failed. Sufficient, hence it is. The appeal that the appeal is dismissed on contest without any cost. Judgment such and such is affirmed.
So now you have to argue on the points of law.
Points of law also I showing the plaint and deposition of the commissioner.
Now, concurrent findings cannot be gone into in second appeal. If there are concurrent findings by the both the courts.
Concurrent finding, lordship, substantial question of law regarding
On these 2 points, you have to argue.
Yes. To
That
that
is-
extent, lordship, I showing the commissioner report also
So let us
and deposition.
no, for considering these two proposition of law, this commissioner report is not necessary.
No, because of the
Because the
second,
jurisdiction point.
no, second point, lordship, kindly, second substantial question of law, second point. Second point, whether both the courts below are justified in passing a decree for demolition of part or portion of a building which has been constructed illegal in violation of the aforesaid rule solely on the basis of the inspection report. So that inspection report must be placed and evidentiary value of this inspection report and whether commissioner can.
No, first of all, question is whether this
Should he maintain
commissioner
a plot?
report should have been accepted at all. That is the question of law.
Lordship.
You see, not the commissioner's report is irregular or incomplete, whatever. Whether commissioner's report should have been accepted at all
Yes.
by the trial court. That is the point of law.
Yes.
So, no question of going into the facts.
Yes.
You have to argue on these 2 points.
Loss.
That is the maintainability of the suit on the basis of the facts and whether
Yeah.
the commissioner's report ought to have accepted at all.
At all, lordship.
These are the 2
And
points.
also, so that, lordship, what is the report saying, contents of the report should be placed. Because of that, the local, as per law, commissioner has authority to that extent, but giving the report to that extent. And deposition, what is the extent?
Can
So
you argue on these points or with authorities?
Yes, yes.
Point number 1 and point number 2.
Yes, yes. Lordship, then fixed another date, I came back.
Yes, record an order.
And lordship, interim order may be extended.
Learned advocates for the parties are present. Learned advocate for the appellant submits but could not conclude his submissions. Let this matter appear on Degun Kobayaj.
Date telling.
(17/9, 2026) at 2 p.m. The interim order granted earlier. The interim order granted earlier stands extended for a period of 7 weeks or till further orders, whichever is earlier.
Yes.
Anyway, let some other date be fixed. Acha. Yes, item number 10. 10 and 11. Uh,
Milord, Lordship would fix up a date, Milord. 11.
This item 11, 12. Learned advocates for the parties are present. Third learned advocates. Let this matter appear for further hearing on কবে
আরে এক সেকেন্ড এটা তো আগে এটা তো করতে দে
না 17 নয় 17/9/2026 at 10:30 a.m.
Obliged to my lord.
My lord, को बोल ताले बोले. My lord, there are 4 matters fixed with Mr. Singh. On the first occasion, Mr. Singh was out of station due to his daughter's admission. The matter could not
No,
have
can
taken-
this matter be settled?
No, your shift is insurance company appeal.
No, question is even if it is insurance company's appeal, if
No,
it
not
can be
Milord, in this case, the injured claimant, Milord, did not suffer any loss of income, neither the loss of salary nor any subsequent.
So settle it before the local.
Yeah, Milord, he is not willing to.
No, why you will not be willing to? You see, the matter cannot be taken up before 17. So prior to that, a local adalat will be held.
Milord, let it go.
Learned advocates for the parties are present. Hard learned advocates. ওটা কেটে দিন, হ্যাঁ? As there is a chance of settlement in this matter, let this matter be sent to the National Lok Adalat. Fix 17/9/2026 for report of the Lok Adalat and further orders.
You know, see, earlier occasion also, you know, see, there are some matters referred to local.
No, this matter was not sent.
No, earlier local matter was fixed. Thereafter, you see, the matter was not settled.
No, it was
But,
not settled. Then those matters will be taken up.
No, in spite of that, the file is there, the matter is not listed, not being.
Anyway, first of all, you mentioned it will appear under the heading hearing, and
You'll
thereafter
start
it will
giving
be
the
fixed.
And also, there are 4 matters, Your Lordship, which I'm telling Your Lordship. Only part 2 occasions the matter was fixed, Your Lordship. One, Mr. Singh was not present also due to
Yes.
daughter's admission, and the last Friday, so insurance company appealed the client's property.
Last Friday he was
Matters
not
in
here.
the list, Your Lordship, in fix any day, Your Lordship.
In those matters also, those matters were not settled before Lok Adalat, or it has not gone there.
It has not gone there,
It
perhaps.
has not. If it has,
But this matter would not be settled.
no. Let Mr. Singh take instruction.
Milord, I can't recollect, Milord, like that.
No.
Milord, there were 4
Taking the
matters.
point of
If it has not gone to Lok Adalat, you see,
Milord,
let
Milord-
it appear as to be mentioned. Thereafter,
My lord.
thereafter
Yes,
you
yes,
take
yes.
instruction.
Yes.
Let it be.
Yes,
Let
yes,
it go there,
yes.
and thereafter I shall.
I
fix it.
understood, Milord. Let it appear as to be mentioned.
Acha, give the slip. Let it appear as to be mentioned. If the records are here, next Monday it will appear as to be mentioned.
Milord, next matter, item 13, Your Lordship will also fix up a date, Milord.
Item 13. Who is
Mrs.
appearing?
Ghosh is there, Milord.
Yes. What is the?
Milord, this will not take much time. Any day, my lord, it is convenient for Your Lordship. Milord.
163A.
It did it 163A? No, 166 though. But Milord, it won't take much time, Milord. That I can assure Your Lordship.
Now, is your client willing to settle this
Milord,
matter?
not this only, sir. This needs the blessings of Your Lordship, Milord. 10 minutes of time. Milord, after my lord comes back, Milord, we will do even then also.
Learned advocates for the parties are present. Item 13.
13, Milord.
Okay. Hard learned advocates. Let this matter appear for further hearing on. 9 ki 10 কবে আছে? 11/9/2026 at 3 p.m.
আপনি আগে বলেন না।
ও আচ্ছা আচ্ছা 11 তারিখ রেখে ও আচ্ছা ঠিক আছে 11/9/2026 at 10:30 a.m. Which year matter?
Milord, this
2013.
is the Milord, FMA of 2013.
Okay, I
I'll
shall
get it disposed of for the next year. Grateful.
Lord, item
come.
Yes, I believe he's in online. Mr. Karmakar.
Milord, in this matter, I am special officer in this matter, Milord. Kindly, I file my report, Milord.
Report probably you have filed.
No, earlier occasion, Milord.
Okay. Ajay, learned advocate for the appellant and learned special officer is present. Let the report filed by learned special officer be kept with the record. Further remuneration of 100 GMs be paid to the learned special officer. Let this matter appear for hearing. So today there is no time, 3:30. Let this matter appear for hearing on মানে সেপ্টেম্বরে 17 তারিখে হবে কি?
No, your lordship already fixed 2 matters in 17th at 3 p.m. just now.
16 তারিখে হবে না? হ্যাঁ 15 দেখুন পনেরো তারিখে দেখুন 15 বা 14 14তে 3টের সময় 14 বা 15তে ওকে 15/9/2026 at 3 p.m.
It cannot be possible at 2 p.m. instead of 3 p.m. as because every day post.
Other matters are fixed. ঠিক আছে today there is no time.
date should be paid from last 12 days going on, my lord. Item 15. From
Item 15, let this matter appear on,
Can be taken on Tuesday, my lord, on 17 or 16.
let this matter appear on 21 তারিখে থাকে 21/8/2026 কটা আছে ফিক্স
Part had matter already, my part is
বেশি হ্যাঁ ও তো ফাইনাল হিয়ারিং হবে না ও যা রিজার্ভ হবে জাজমেন্ট আর কি 21/8 আচ্ছা তাহলে 20 তারিখে হয় যে 4টের সময় দেখুন তো
4 p.m. Can it be fixed at 10:30 or 12? 4 p.m.
20 তারিখে কি 1টার সময় দেখুন 20 তারিখে at 11 a.m.